these days I'll be alright. There's nothing here that I don't like. Just being me, living through my scars as I watch the clouds near and far. Hard to live within the truth, the memories of my youth. I'm doing my best to get it together, no matter the storm of the weather. Living like I had nothing to lose, not allowing them to light my fuse. I know I can't be the only one, a different path I never dreamed I'd find. It's a beautiful day to start with own mind. Live your best life, I'm not crazy. Stay a while, don't worry about tomorrow. Live for today, one of these days I'll be alright. There's nothing here that I don't like. Just being me, living through my scars as I watch the clouds near and far. To live what's in the truth, the memories of my youth. I'm doing my best to get
it right there, guys. I'm finishing it up.
Storm of the weather, living like I have nothing to lose, not allowing them to light my fuse. I know I can't be the only one, a different path I never dreamed I'd find. It's a beautiful day to start with on my live your best life. I'm not crazy, stay a while, don't worry about tomorrow. Live for today, one of these days I'll be alright. There's nothing here that I don't like. Just being me, living through my scars as I watch the clouds near and far. To live within the truth, the memories of my youth. I'm doing my best to get it together, no matter the storm or the weather. Living like I have nothing to lose, not allowing them to light my fuse. I know I can't be the only one, a different path I never dreamed I'd find. It's a beautiful day to start with on mine. Live your best life, I'm not crazy. Stay a while, don't worry about tomorrow. Live for today, one of these days I'll be alright. There's nothing here that I just me and me, living through my scars as I watch the clouds near and far. To live what's in the truth, the memories of my youth.
All right. So, hey. Hi, guys. Welcome in. Rubber here. It is Monday. I don't even know what day it is. It is May 18th. Y'all. Okay, it's May 18th. Hopefully my TV is not too loud. If y'all can hear the TV too much, let me know and I will have them turn it down. As y'all seen, I had planned to be live earlier, but the drama of a man losing his wallet is real. Okay, it's real. He was supposed to leave at 3:45 and it was 5:15 before we found the damn thing, and that was after I dug through the trash. So it was found in the trash can under trash, eating food, banana peels, one of those things. That moment I found it. So we are back on track. I'm here. I'm going to stream. I have a very interesting trial. We're going to start a trial today. Y'all know I haven't done trials in a while. This is a very interesting one. I'm going to kind of give y'all a rundown of what the trial is going to be about. Her name is Ebony Parker, and I will tell y'all a little bit about that on the flip side after we roll the intro. Hoopies!
Rubber in the model room welcomes all. Thanks for stopping by, answering the call. Ups and downs are normal for some of us. Many days I beg to get off this life bus. Neon lights flicker, my shadow on the wall. Dreams on the ceiling, we run and then we fall. Sharing stories over paper cups. Wheels keep turning but never enough. Life's a ride on a rickety old track, holding on tight, never looking back. In the rubber and my
Right, Southern the wallet or the keys, it's a meltdown for a man. It's a meltdown well, it's a meltdown for a woman too, but let me tell you, whew, it was rough, but we found him. Wallet is secured. So, I secret time. I made him go buy me some, Mary Jane for finding it for him and digging in the trash for him. So, I got something out of that deal. I ain't gonna lie. Ain't gonna lie. Anyways, so welcome in everybody. I see Cindy, Southern Cat, see Mastiff, uh, Rainy's here. I know her name's Kim. I always call her Rainy because I was so used to that before they did these at symbol changes. So, it is what it is. And look, Hannah Banana up there. Look at there. Hey, Banana. Anyway, so I'm gonna tell y'all a little bitty story, okay? So imagine it's a Friday afternoon and there's a first grade classroom, 6-year-old kids sitting at their desks, and their teacher, her name is Abigail Zwerner. Okay. She's reading a story. She's 25 years old. Okay. She's reading a story to these children. Suddenly, one of those 6-year-old kids reaches into his pocket. He pulls out a loaded 9 millimeter handgun. He points it directly at the teacher and he pulls the trigger. The 6-year-old pulled the trigger. The bullet tears through her hand and into her chest. Think about that. You have a class of 6-year-olds, first grade. Okay. So it's a horrific shooting. It's from January of 2023. It was at Rich Neck Elementary in Virginia. Today, history is being made in the courtroom, though, because the trial for Dr. Ebony Parker, who was the school's assistant principal, now the former assistant principal, is on trial. She's she's facing public backlash. She's facing criminal charges. So far, there's 8 felony. What? Sorry, not so far. There is 8 felony counts of child abuse and neglect, and they're saying it's one count for every single bullet that was left inside that 6-year-old's gun. So if the jury finds her guilty, she's going to face up to 40 years in prison. Now, it's the whole story went from a tragedy to a massive legal battle. Okay, it went to a whole legal battle. There's all kinds of stuff going on with this. Um, so the prosecutor is trying to say that the shooting was entirely preventable, and they're arguing that Ebony Parker didn't make a mistake. They allege that she showed reckless disregard for human life. So let's look at the timeline, and it starts before the first bell even rings. A 6-year-old boy steals the gun from his mother's purse and slips it in his backpack. By mid morning, the warnings start flooding into the front office. So the people at the school know they're hearing about this. There's rumor about this. So the first warning number one, a little boy comes forward. He tells the teacher that this student showed him a gun and threatened to blow up the school. That teacher alerts administration. Warning number two, 2 more students come forward. They saw the weapon. Warning number three, a school counselor was so deeply concerned that he asked Dr. Parker for permission to search the boy's backpack. And the response, according to the prosecutor, Dr. Parker denied the search. She allegedly told the counselor the boy's pockets were too small to hold a handgun and told staff to just let the school finish the day. Hours later, the gun went off. So here we are today, March 18th, 2026. Ebony Parker has walked into that Newport News courtroom and she entered a plea of not guilty. So what I'm going to show y'all is there's a few videos There's a few videos of, pre-trial and everything, and today the trial started, but it started with a voir dire, no, another one of those words I can't say just right. It was a voir dire, and it was quite interesting, the questions they were asking, so we are gonna watch a little bit of that today, and then the actual I'm pretty sure the actual trial with opening statements will be tomorrow. So we're going to start over here. Let's see. That's me. Let's not look at me. Well, gotta share the screen, Sheila. My screen's freezing. My screen's freezing. Is it still freezing, Cindy? Nope. Trying to find the right spot for me. Okay. I'm back now. Okay. So you got most of that, right? I'm good. I'm good. Okay. So this is Virginia versus Ebony Parker. She's a first grade school teacher. Let me see if I can make this. I can't make this any full screen any bigger. So what we're gonna do is kind of read through this, just to kind of get a rundown, and then we're gonna listen to a couple little news stories, and then we're gonna watch part of the Vaudier today. So this is the assistant principal of Virginia Elementary School is standing trial for failing to act before first grade student first grader shot his teacher with a gun. Ebony Parker is charged with 8 counts of felony child abuse that is pleaded not guilty. Parker was the assistant principal of Richneck Elementary School on January 6, 2023, when a 6-year-old boy identified as JT because he was 6 years old. And another little bit of info JT is not facing any charges, I don't think, which he's 6 years old. The mother has faced charges. The mother has been charged and has done charges. There's also been a civil suit. We're going to review some of that before we actually get to the Vaudier today. So Parker was the assistant principal of Richneck Elementary School on January 6, 2023. Hang on, I'm gonna put me behind this so y'all can see that better. Um, when a 6-year-old boy identifies JT pulled out a gun and shot his teacher, Abigail Zwerner, in the hand and chest. Zwerner, who suffered serious injuries in the shooting, claimed in a civil lawsuit against Parker the student who had shot her had a history of issues, including an incident where he attacked a teacher. On the day of the shooting, one student told teachers that JT had shown him both the bullets and the gun and threatened to hurt us, blow us up. 2 other students also reported that the child had a gun in his bag. Teachers and a school counselor testified at the civil trial that they had concerns about the student and had wanted to search his backpack before the shooting. When she testified at the civil trial, Zorner said she had gaps in her memory from the day of the shooting, but said she remembered thinking she had died. I thought I was dying. I thought I had died. I thought I was either on my way to heaven or in heaven. But then it got all black. And so then I thought I wasn't going there, she said. My next memory I see is 2 coworkers around me and I process that I'm hurt and they're putting pressure on where I'm hurting. Prosecutors say that Parker ignored warnings and refused to grant permission to search the child's belongings and allegedly told other teachers she thought the child's pockets were too small for handguns. Did resign shortly after the civil suit was filed. Her defense has argued that the civil trial that nobody could have expected a 6-year-old to bring a gun to school and said she followed proper protocols and procedures on that day in question. She's appealing the civil jury's $10 million award, which was stayed pending a post judgment hearing. And if convicted, she faces a potential sentence of 1 to 5 years on each count. So let's see. So this was 6 months ago. This was the jury returned a. Okay, hang on. I gotta pull it down and put it back up because It stopped. Yeah, you're flat. I am too. I am too, Hannah. I mean, I'm I can't believe this is even real. Um, I'm yeah. So a jury has returned a $10 million verdict in favor of the first grade teacher Abby Zwerner against Rich Neck Elementary School's former assistant principal Ebony Parker. Zwerner was shot and she sued alleging that Parker had ignored repeated warnings. So this was the end of that hearing. So we're going to listen to this real quick. It's 13 minutes long. They kind of talk about it a little bit, so you get to know a little bit more about the trial. You're gassed or flabbered. Yeah, I when I heard about this, I wanted to do the Millette trial, but it was a 3-month trial and it's not being televised. So here we are. I found something different. I wanted to do a trial. It's just something I wanted to do. So let's listen in.
Beginning on June 1st, 2024.
Thank you, Madam Clerk. Any requests from the plaintiff? Any requests from the defense?
That we schedule time for post-trial motions.
All right.
And
All
may not be heard on the verdict today.
All right. So the court will withhold entry of a judgment order in the case. The court will further reserve all rulings and hearings on post-trial motions for a later date to be set by the parties. Anything else to take up at this time, Mr. Beniozen? Ms. Douglas?
No, Your Honor, thank you.
All right. Ladies and gentlemen of the jury, your term expires tomorrow, so you were...
I'm sorry, I was talking. That was so rude. Hector was trying to tell. I'm not used to streaming with people home, and Hector's trying to talk to me and told me he can't do
reserve
that.
all rulings and hearings on post-trial motions for a later date to be set by the parties. Anything else to take up at this time, Mr. Beniozen? Ms. Douglas?
No, Your Honor, thank you.
All right. Ladies and gentlemen of the jury, your term expires tomorrow, so you were still admonished by the court that because you still are in term, that you are not to talk about any of the cases that you've heard during this term, but you do not need to call back. Thank you very much for your service. It is an important service to all of us, and I know it has been a difficult service, but one that is necessary for the resolution of disputes in this country that I'm very proud
And that's
that we
the
get to
teacher
exercise those rights.
right here. This blonde
Ladies and
lady.
gentlemen of the jury, you are excused.
This blonde lady right here. This is the teacher, Abigail. She was shot in the hand, and it went through into her chest.
Please rise for the jury. You may be seated.
All right. The plaintiff and her attorneys are excused, as is the defendant and her attorney as well. You may follow, if you so desire, my bailiff.
That's them walking out. So that was her being awarded her $10 million. Now, we're going to also look at this. This I found interesting. Hang on. Why did it do that? So this was on November 10th. So this is a look ahead into, this was posted November 2025. It looks ahead at Ebony Parker's criminal case. Parker was assistant principal. So I'm not sure who this is testifying, but I found that there wasn't a lot out there to see any pre information before what this trial is going to give us. So I found what I could, and this was one of those.
Once you heard the shooting, what did you think that was?
I knew it was a gunshot.
How many times was she shot? How many gunshots did you hear?
I thought I had died.
Do you have any opinion on whether Dr. Parker could have foreseen JD's actions that day based on the information that she had?
I think it would be difficult for anyone to have foreseen that.
Well, it could be tipping the scales in the criminal trial for the first grader shoots.
I'm going to turn off my camera and we're going to watch this quietly, and I'm going to not do a whole bunch of interrupting. Y'all know I talk a lot. I talk a whole lot, but in trials, I try to keep it on a down low. It's been a while since I've done a trial, and y'all know me and my mouthy talking, so I'm going to try really hard to be quiet. So I'm going to mute and let them talk.
Teacher case in the case against Dr. Ebony Parker, the former assistant principal of a Virginia elementary school. Abby Zwerner, the teacher who was shot by the 6-year-old, won her civil case. We watched that play out here on Court TV.
We, the jury, on the issues joined, find in favor of the plaintiff, Abigail Zwerner, and assess her damages at $10 million. The award interest beginning on June 1st, 2024.
That was $10 million. It wasn't her money. You know, I'm sure she was a little disappointed by the civil jury's verdict, but now the criminal proceedings are ahead, and she is charged with 8 counts of felony child neglect. What can we expect at the trial? How might witnesses here play
and I can't get over that, okay, yes, I'm pausing and speaking, but I'm trying not to. I'm really trying not to. Hey, Mustang, how are you today? So I'm really trying not to. But 8 counts, and that's 1 count for each bullet left in the weapon. Let that sink in. It just seemed like a strange, because they could have injured 8 more people with what was left in that. That was the only thing that I can figure out. So give me y'all's thoughts in the comments, because they may tell us, but y'all know me and my jumping the gun and thoughts, because I don't watch everything. We do this raw Rubber Ramada reviews.
factor into the criminal courtroom and civil night and day? We have with us an attorney representing many of the students, 8 of them, and an adult. Let's bring her in here to discuss. Emily Brandon. Emily, good morning to you. First, what is your connection to the case? You're representing students, these 8 students. What's your role? What's the student's role and the adult that you represent's role here as we move forward towards this criminal proceeding?
Thank you, Ted. Yes, I represent 8 students who were witness to the shooting in the classrooms. And I represent an adult who was actually on school grounds that day to pick up a grandchild and ended up in the melee in the front office and actually did render some aid to Abby during the commotion before first responders arrived. And the basis of those lawsuits is related to the emotional pain and suffering, along with some physical injuries such as sleepless nights. We've had some kids that have experienced bedwetting, flashbacks. Most of them have been diagnosed with PTSD following this event. And so that is the nature of the cases that I have, which are civil.
Turn your mic on, Sheila. And again, this goes to now all these kids that were subjected to this. Here we go with the mental health, and y'all know how I feel about mental health. So,
in nature.
And is the assistant principal named in this, or is the district is the same scenario as we saw with Abby's lawsuit?
It is the same scenario as Abby's lawsuit. However, in my case, everyone is still in the case. So in Abby's case, right before trial, I think back in maybe July of 2025, there was a hearing, and the school board and Dr. Foster Newton were both dismissed from the case, leaving only Ebony to stand that trial that you just finished up last week. In my case, we haven't made it yet to those motions. And so every entity is still in my case as a defendant.
Gotcha. It makes sense. Let's talk about the criminal case that is ahead here. What are your thoughts? I mean, the civil, I get you'd sue her, but should this woman, she had a horrible day at work. She made every wrong decision you could argue. Should she go to jail or prison for that? What's your take on the state going after her criminally?
Well, I think it's important for people to know that this was a very special proceeding that happened in order to bring these charges, which was a special grand jury. So in Newport News, they convened a confidential, I believe, special grand jury, and they heard evidence over a course of about 2 to 3 weeks, which is essentially like a trial, but with a lot less of the rules. And their job was to determine if they felt, based on that evidence that they had heard, was there enough to bring these charges? And they decided yes. And I don't know if you've read the report that they wrote, but it was scathing. I have never seen a special grand jury report with such detail and frankly emotion. And I was there during those proceedings because some of my clients gave testimony in that special grand jury proceeding. And it was really hard to hold back tears from most of the people in the room when you heard from these parents. And so it's a tough question to answer because we're all human and we certainly have sensitivity to and sympathy for an individual who's facing so much for this one event. But wow, obviously a group of her citizen peers felt that she failed these children and she failed everyone in the school that day. And that's why these charges are here.
Your 8 students that you represent, and how many?
Can you imagine? I'm just trying to put myself in a position of an educator and knowing that these things are happening and you're telling your assistant principal, hey, this is what's going on. And she chose not to, in my opinion, would do the right thing. And that would be to go ahead and find a way to search this young child to make sure there was nothing there. I'm at a loss for words, really. So I really wanted to share this with y'all. So sorry, I'm going to let them talk.
They will be testifying. How do you prepare them? I mean, will you be there? Do they have to testify? What do you know now, and what are you getting ready for?
Sure. I have at least 4 clients who will testify in the criminal trial.
Oh, well,
they are prepping.
There we go. Okay. Something we learned. And this is supposed to only be a 4-day trial, so.
With the prosecutor in that trial, because as you know, the prosecutor is the lead attorney in that case. He is bringing the criminal case against Ebony on behalf of our Commonwealth. And so I have a role in that, in the sense that I'm helping my clients navigate, which is what is a very scary process, but I don't have a role as an attorney in that case. But I will be there standing beside them, especially those that are speaking. And they've been prepping over the past 2 weeks. Some of them won't testify, and it won't be any children. It will be parents and adult witnesses.
Okay, great. There's no kid. I mean, the kids were so young. One would hope that they wouldn't have to endure that. Let's listen to some of the employees at the school that testified during the civil proceedings. You could feel the emotion from them.
Okay, y'all buckle up because, again, I haven't watched. So, Cindy, trigger warning for me, please, if you're still here. Or any mod that can. TW. Whew.
Take a listen.
What did you do after you heard the frantic call? I know, Mr. Rawls. It's okay.
He shot her. You know. I said, he did what? And she said, yeah.
Did you hear the shooting?
Yes.
Okay. Once you heard the shooting, what did you think that was?
I knew it was a gunshot.
And where did you think it had come from?
Abby's room.
A 6-year-old. It's so hard to get your head around. That was part of Dr. Parker's defense, which I'm sure we'll see play out in the criminal proceedings as well. A 6-year-old we don't think should have a gun and not bring one to school and not be able to use it. There's so many things that you can't get your head around. And then that's what you saw there, that emotion. Do you expect that to play out again in the criminal proceedings?
Yeah, absolutely. That was Rawls that you just played. I was moved by his testimony as well, because I know they're all just people that were at their regular job that day. And I know that these other teachers feel some level of personal responsibility. And I have to say, this is probably unpopular opinion, but the takeaway for me from the civil trial in the last 2 weeks, as I watched it in live, by the way, I really am grateful we had that opportunity for Court TV to stream it, because my clients could watch it from home and they didn't feel like they had to sit in that courtroom with all of the news. So that was really something great for them to be able to watch from home. But one of the first questions that I had when I learned about these cases in January of 2023, everyone's focused on Abby, obviously, because she was very, very injured and it was a serious incident. But I just couldn't help but ask myself, why didn't anyone do anything? And what about these kids? Because for the longest time, we didn't hear about the children at all. It was just about Abby. And as I'm hearing about the testimony with what happened on the playground, there was a period of nearly an hour where 40 children were with a child who had a weapon, a gun, in his sweatshirt.
Yeah.
And she knew that.
Yeah. And it's horrible. The whole case is horrible. We appreciate you, Emily, coming on.
Okay. So, because I want to give y'all a little bit more insight. Okay. So I'm gonna run this trial. This trial is gonna be a 4-day trial. And like today was basically just all the voir dire, which I thought was interesting with the questions, and we're gonna watch some of that. But this is actually from July. No, this premiered November 5th, 2025. So these are closing arguments from her civil trial that we're going to watch. So this kind of just gives us a little insight into what it is that we're actually getting into.
Perfect timing. We're in Virginia this afternoon. Closing arguments just getting ready to begin in the first grader shoots teacher civil trial.
Yeah, we're about to hear from.
Now, again, this was the civil trial, which we already know the outcome. She got a $10 million award, but now we're in a criminal trial because it's Virginia against Miss Ebony Parker. So there'll be some changes in it. I'm not sure exactly which way they're going to go with all that. Sherry Berry, good evening, love. How are you? I hope you're doing well. We're doing some crazy trial. We're getting a little insight into what's happening. We have Baudir to go through a little bit. We're not going to watch all of it, but some of it because it's quite interesting. And this little 6-year-old got a handgun out of his mommy's purse before dropping him off at school and shot his little first grade teacher with all these other little 6-year-olds in the class. So this is going to review the information. And again, this was the civil part. So this will just kind of give us an insight.
The plaintiff's attorney, the one who's representing Abigail Zwerner, she's a teacher who's suing the former assistant principal at the school where she taught. This is after a 6-year-old first grader had a gun on the campus and shot her. And she says that principal ignored warnings and thus she's going to be suing her. We'll see for how much. But the initial.
If I would just let her talk, she'd have told y'all all that. But see, here you go. I know my shit for once. You have a question? Tell me your question. Do you want to, girl? Y'all know. If any of y'all want a link to come up and talk, you don't ever have to turn your camera on. But I will always drop links for questions, discussions, and any of that. I'm always open for discussions. You just have to ask for a link. That's me. That's how I do it. Oh, you have. Well, I am glad, Sherry. I'm glad. So you know what I'm talking about then. So. Yeah. So anyways, ask your questions, Southern Cats. But like I said, and if anybody ever gets, y'all, my regulars know, all you got to do is ask for a link. I'll drop one. I'm more than willing to have a chat, why wasn't it secured? Geez, that would be a question for the mom, but I don't know. I didn't watch the civil trial. So like I said, this is a closing, so we're going to watch and let them go through these closing arguments, and let's see what they tell us.
The lawsuit was for $40 million.
Yes, ma'am. Yes, ma'am. But be sure, Hannah Banana, wash. Say your ABCs frontwards and backwards, and that's it. And then you can come back.
The hand and the chest back in 2023. All this happened in January. She had a collapse lung. Let's go in. The plaintiff's closing argument has begun.
Splatter. Scary.
A gun changes everything. At least it should. And on January 6th, 2023, a gun walked on the campus of Rich Neck Elementary School.
Wait. Okay, y'all. Damn it. See, this is my problem. I try not to be a smart ass, but what did this man... This man just said a gun walked on the campus. Sir? Sir? Guns don't have legs. I'm sorry, okay?
On the campus, 2023, a gun walked on the campus of Rich Neck Elementary School.
Guns don't walk.
That gun changed the thoughts of every student who saw it, heard about it, staff member.
Your Honor. Objection.
Uh-oh.
It's not about the students.
Over. You may proceed.
It changed what they did, where they went, and it changed one young woman's life forever. Except it didn't change the actions of one person. It didn't change where Dr. Parker went. It didn't change what she did. And those choices that she made to treat January 6, 2023.
I'm gonna let y'all know. I'm not gonna put the chat on screen because if you don't know me by now, I don't delete anything. Everything of mine stays up, including all the chat, unless I have to go in and like take some music out or something that we kind of sort of accidentally played and shouldn't have played, which I'm being a little more particular about that. So yeah, I'm not gonna I while it's great seeing your chats up on screen and everything, I don't delete my chat. So if anybody ever goes back and wants to review my streams, all the chats are there. Enjoy.
Like any other day, even though a gun should change everything, is why we're here today. We're here today to ask you to do something that we can't do alone. And the thing that we cannot do alone is that we cannot achieve accountability by ourselves. That's what jurors are for. That's what you all are here to do if you find that accountability should be had. And you all may have different jobs when you walk outside of this courtroom. You may have different obligations in your personal life. But when you're in this courtroom and you walk back to that deliberation room, if you're one of the jurors that decides this case, your job is to deliberate together and return a unanimous verdict. And in doing that, one of the first things you all will do, if the judge hasn't already told you, is you're going to pick a foreperson. And that foreperson's responsibility is to make sure that everyone participates in the verdict, that everybody's voice is heard in that room, that everybody chimes in and shares their ideas and talks about the evidence. And the reason for that is that the 9 of you who are here and the 7 of you who will decide this case are here as representatives of this community to voice their conscience of what's right. Just like yesterday was election day and we all cast our ballots, you all are here individually, but as part of this community to decide what should have happened on January 6, 2023. And when you're in that room and you're deciding these issues, there may be times where you disagree. And the hard part of this is you've been here for a week and a half and you get to know each other, and sometimes we can hear you laughing as you come out, which is great. And you've made friends. But when you get back into that jury deliberation room and you're talking about the issues in this case, and you're talking about how to decide something, you're going to have to speak and share your thoughts. And we're asking you to fight. We're asking you, when you get back there, to fight for what you believe is the right outcome in this case. And when you're doing that, one of the instructions that I will point you to, and the judge talked about it and I talked about it earlier when we picked the jury, is the burden of proof. We talked in voir dire, if you remember, we said this isn't a criminal case where you decide things beyond a reasonable doubt. And I may have done this with my hands, depending on which group you're in. I say this is a case you decide on the preponderance of the evidence. And I show you this because when you get into that deliberation room and you're fighting about issues, or you're trying to decide something, and look, I hope you get back there and everybody takes a straw poll and says, you're with us. I hope it. And we've put on enough evidence, I think, that that may be true. But as you're deciding those issues, this is where you come to. This question of what's more likely true than not true. That's the burden of proof in this case. And so with that, I'm going to take a step back and I'm going to give you a roadmap for what we'll talk about. This is called summation. It's my chance to tell you all what I think the evidence was, but you all were paying attention. You all took copious notes. And candidly, if the judge lets you, I'm sure you could come up here and give closing arguments yourself.
Here, let me. Oh shit, wrong button, Sheila. How do I make this big? Oh, right here. Look, I think that. Wait, nope, that makes the whole screen big. Damn it. Here, look, put me in the back just so y'all can see. Okay, look. The gun allegedly jammed after the first shot. The teacher survived and is suing the assistant principal. So that's what I see. The mom did have charges against her. I'm gonna pull that up while we're playing this. I'll pull up the charges with the mom. Okay.
And tell us what this case was about. I think you know it that well. So my goal here isn't just to tell you what you heard from that witness stand or what you saw on that TV. My job here is to try and talk ideas so that when you get into that room and you're having those discussions, you have an idea of, okay, how do we resolve this? What are tactics that we can think through and process, and how do we answer these questions? And some you may like, and some you may not, and that's okay. That's my job so that I can help you do your job in that room in however long it takes us to get there. So what I'm going to do is I'm going to move pretty quick. We've already talked about your job. I'm going to move quick through the second stop, which is what I'll call fault. And we're going to focus on what Dr. Parker's job was. Then I'm going to talk about the blame game. And then if you'll let me, I'm going to slow down and I'll talk about costs and consequences at the end. And the reason I slow down is that it sounds like we're going to go fast, and we're going to try and go fast through the first part, but I don't want to lose grasp of what we're really here for. And that's to talk about the effect that this has had on this one. Sound good? All right, we can go to the PowerPoint.
Okay. I do have information about the parents. Y'all want to, do you want to switch over to the mother and hear about that real quick? And then we'll go back to these closings, or do y'all want to finish closings? Up to y'all. Let me know. 1, finish closings. 2, we learned about Mama Deja. Let me know. Let me know. Put it in the chat and we'll do it. First 2 gets the win. 1, we finish this. Look at that goddamn 80s. Look, this is my problem. No dirty feet in my chat. Only duck feet because they've been in the water and in the duck pond. So you better have some clean feet, 80s. What are we gonna do, guys? We're gonna finish listening to the closing. Okay, you want to finish listening to closing and then do the mom? Is that what I thought? Because I think. What? Okay, we're gonna finish doing this and then we'll switch over to the mom.
So, your roadmap: fault, blame, and cost. Fault. Her job is safety. Dr. Parker's job is safety. We talked in opening statement about promises. Do you remember that when Ms. Toscano came up here and we talked about expressed and implied promises, the things we say and the things that are meant with what we say? And when we get out onto the road, I know a lot of us don't have keys with keys anymore, but there's still keys out there. I'm Forerunner. You put that key in the ignition, you turn, and as you go out on
It is scratchy. I thought maybe it was my headphones. So I unplugged my headphones to see, but that's the court being scratchy. That's not me, guys. I'm sorry.
onto the roadway, you're making a promise. You don't have to say it to people. But what you're saying is, by strapping your seatbelt and going out onto the highway, you're saying, I promise to look out for you. I promise to see the stop signs that are there to be seen. I promise to stop at those stop signs. I promise to turn my blinker on when I go to change lanes. I make these promises because you rely on me to make the promise and I rely on you to make the promise so each of us can go home at night and see our families. We make those promises even though we never say them out loud. And then there are promises that come with what we say or how we say them. There are promises when you answer the phone and agree to take action or to find something out. And then the question becomes, what happens when you put the phone receiver down on the table and you don't meet that promise? That is what the judge was talking about when he instructed you on what's called Instruction 16. And this is the law to govern you in this case. It says a person who undertakes gratuitously or for consideration, in other words, whether you're paid for it or not, to render services which she should recognize as necessary for the protection of the third person, is subject to liability, talking about fault, to the third person, in this case, we're talking about Ms. Zwerner, for the physical harm resulting from her, Dr. Parker, failure to exercise care to protect her undertaking. So what does that mean? And we'll get through some of this evidence in a moment. But whether it was on a phone or through a doorway, around noon on January 6, 2023, there was a communication. And that communication involved a gun and a backpack. And she answered the call. And the question that you have to decide now is, by answering that call, by making the promise that I'm going to find something out, explicitly or implicit, we can talk about other promises later, did her failure to exercise reasonable care, in this case, did her failure to act, to do something, increase the risk of harm to Ms. Zwerner? Or, it's an or question, not an and, did Ms. Zwerner suffer harm because she relied on the third person? That is, she relied on somebody to act. That's our framework, right? That's what we're talking about in this case. That's the law that governs your decision. And let's talk about facts as they come through them. You're going to hear, before I do that, I have to explain this thing of negligence that we talked about. You've heard this word negligence. You've heard the judge talk about gross negligence. We'll look at the instruction a little bit later. Best way, I know how to explain it. Okay? Hang with me. If I had a baseball and I turned around, sorry, Keith, Mr. Williamson, if I turned around and I thought, I'm going to try and hit that gavel off the top. Actually, I'm going to change my mind. I'm just going to point right at Mr. Williamson's forehead. And I threw that ball, meaning to hit his forehead. That's what we call an intentional harm, right? You get it? I meant to do it, and I did it if I threw the ball. Negligence is knowing I'm not as good a baseball player as probably the judge. If I looked up at that gavel and said, or maybe that apple, said, I can probably hit that. And I...
Okay, a bit of a
situation. She was observing this
break.
And you know, on court TV's time, they freaking do all this shit and we lose.
Argument starting with the plaintiff.
And I threw it and I hit Mr. Williamson.
Bear with me, guys. Y'all know I can do this. It's been a minute, but I can do it.
But it was not the wisest choice. Opposing counsel said at one point in opening statement, it was inadequacy. Remember that line? It's not indifference, it's inadequacy. We'll come back to that. It's not quite what I should do. Gross negligence. If I turn around, sorry, y'all, and I decide I'm going to try and throw the ball to Mr. Bright. And in between Mr. Bright are Ms. Zwerner and Ms. Toscano. The risk of danger has gone up, right? It's going to be harder for me to throw that ball. And the truth is, I ain't that good at baseball. And so there's just as good of a chance that I throw it at him or I hit one of these two. That means I'm kind of indifferent. I may get it done, I may not. That's what we call gross negligence. The risk of harm has increased, and I'm somewhat indifferent to the outcome.
I like how it's
explaining. And then we talk
this.
about recklessness, which is in one of the instructions. Recklessness is saying, I'm going to try and hit that back wall through that crowd of people, and by golly, I hope I do it, knowing the likely outcome. So we have levels to this, if you want to think of it that way. And the question is, how great is the danger? How great is the harm, the risk of it? And when I act or fail to act, how likely is it that something's going to happen? So, we've seen a lot of faces. We've heard a lot of testimony. I told you I'm not going to go through everything, but let's go through this. I told you at noon or around noon that day, there was Ms. Kovac was told that by two girls that there was a gun. What we know is that Ms. Kovac shared that information with Dr. Parker. And what I'm going to come back to throughout this closing argument, throughout this summation, is that every minute matters. Every minute matters. Ms. Kovac says, we think the gun's in the backpack. And according to our expert, Ms. Shufflebarger, as you remember, at that moment, a gun changes everything. A gun changes everything. You stop and you investigate. You get to the bottom of it.
Absolutely.
You get to the bottom of that backpack. You get to the bottom of his pockets. Whatever it is, you get to the bottom of it to know whether that gun is real and on campus so you can deal with it. But that's not what happened. So later, a communication comes back. We think it's put in the pocket.
I'm going to tell you, she looks very uncomfortable. She looks knowing it was a $10 million outcome. And this was only a civil trial. And now she's on a criminal trial. Eek.
And then the check of the backpack happens and it's gun out of backpack. And this is where we have the line, there are little pockets. It's a line that we heard on the stand. It's a line that you just can't forget when you hear those words. And then you have search the person. And the response is check the bag. And I want to stop here. By this point in the day, Ms. West has asked Mr. Sims to ask Dr. Parker, have you searched the person? And when that communication is read or brought to Dr. Parker, what do we know? We heard in the instructions that evidence can be proven by direct and circumstantial evidence. What does that mean? I don't need to see the rain coming down from the sky to know it's raining if I walk out in the morning and there are puddles on the floor, right? I don't need to see the rain. I know it rained. And when Dr. Parker says, in response to, did you search the person? We checked the bag. What that tells us is that that was a real threat. That it was accepted as true, so much so that we needed to check the bag. All this talk about we didn't think it was a real threat. It wasn't a credible threat. Why are you agreeing with Ms. Kovac to search the bag if you don't think it's real? And when they say, did you search the person? And the response is, we already checked the bag. Guess what that tells us? We thought it was real, and we don't know where it is anymore. We don't know where it is anymore. And then the boy outside of Miss West's classroom crying, remember? Crying, not wanting to go back into Mrs. Z's classroom where he's supposed to be. Says bullets and shoot. The boy showed me bullets. JT showed me bullets. And he said if I told anybody, I would shoot. Bullets, shoot, gun. The only way you can shoot a bullet is if you have a gun. And to tell us that telling a boy that he will be shot is not a threat, not a threat, goes against the very language that 6-year-old used. And then he goes and has a conversation with her again. You heard from Miss West, who said he was crying scared. I talked about R a moment ago. He was crying scared. And I suspect what you're going to hear from the other side is, well, we didn't get good information. Remember that from Dr. Klinger? Well, we didn't get good information.
Need a break. First, Franz Borkart watching from back. Your thoughts on this young man delivering the Let's head back to Virginia now. We're watching the closing arguments in the first grader shoots teacher civil trial.
Yeah, this is a former Rich Neck Elementary School teacher, Abigail Zwerner. She's seeking millions in damages after a student, a 6-year-old, shot her back in 2023. And this lawsuit claims that there was gross negligence in the principal not preventing the shooting, alleging that this assistant principal, Ebony Parker, ignored several warnings that the student had a gun on campus.
Let's go back to the courtroom now, pick up the close from the plaintiff's attorney.
We didn't know that he was crying and scared. Somebody should have told Dr. Parker that he was crying and
Thank
scared.
you, Cindy. That's fine, love.
When we go out onto the road and there's a stop sign on the corner of the street, tuck it behind a little corner or right there for us to see either way. It's our job as we're driving down the road to see the stop sign. It's our job to look out for the stop sign. It's our job to find the rules of the road and the signs of the road so that we can then govern our behavior. It was Dr. Parker's job to investigate. The manual that governed their relationships amongst each other told her that you must first assume it is credible unless analysis suggests differently. Cause the student making the threat, if known and on campus, to be immediately removed pending further investigation. What does that mean? That means you can't stick your head in the sand. You cannot stick your head in the sand and then come into court and say, I didn't have the information when it was your job to find it, when it was your job to look for it and to do the investigation and to talk to that little boy who saw the gun and to talk to those 2 little girls who talked about the gun and to talk to all of these people. If it's your job to investigate, which their handbook tells them it was, you can't come into court and say, I'm going to close my ears, close my eyes, put my head on my desk, and then use that as a defense to my case. The law says you know it because it was there to be known, because the stop sign was on the corner of the street and it should have been seen. It's no excuse to walk into court on a traffic ticket and say, well, Judge, I didn't see the stop sign. The stop sign was there. The stop sign was there, feet, yards from her.
God, he has a point. He has a big point.
And then, in my view, you turn up the dial. Because at this point in the afternoon, there is a accumulation of information. We saw a gun. It was supposed to be in a backpack. We don't know where it is. It might be in his pocket. It was shown to a boy at recess with bullets. We still don't know where it is. He's crying, won't go to class. And another request, can we search the person? And I suspect they'll come up here and they'll say, well, Mr. Rawls told you that he didn't think it was credible. My response to that is let's look at actions, because our actions speak louder than our words. Did we hear any other evidence of Mr. Rawls coming and asking to search just kids at random when he didn't think there was a threat? We talked, and all of the evidence is that searching, and even Dr. Klinger told us, searching a child is something that you do delicately. You only do if it's necessary.
Oh, this is so hard for me to sit through and not talk because y'all know I'm a talker. And my, I'm trying to be very respectful with my comments. But why wasn't he? I don't understand why he wasn't, sir. I wish I could have seen this whole trial, but knowing what this as a preview of the closing of the civil trial and knowing now we're going criminal trial, I'm here for it. I am here for it. I'm going to let it play.
That's what they're taught. And he came to her directly and said, have we searched the boy? Again. And he wasn't the only one in that moment. Because in that moment, when she heard, West heard, that they had not searched the person, Mr. Sims goes and stands outside the door of Mr. Rawls and Dr. Parker and says, are we searching the person? That's 3 times somebody is asking her to do this. 3 times. Countless times where we're talking about the boy throughout the day and the gun and where it is, but 3 times to search the boy. That should be flashing at you to act. And the response? Let's hold off. Let's hold off. It's 1:40 in the afternoon. Mom's going to be here at 2:30 p.m. to pick him up. Let's hold off. I told you that I would talk more about promises, right? When Mr. Rawls walks down the hall, being told directly, let's hold off and wait for mom to come and then we'll take the action. What does that tell us? Like the rain that we did not see. It tells us that she still thinks there's a gun. If she doesn't think there's a gun, what are you holding off for? If you don't think there's a gun, you don't say, we'll wait for mom to come and we'll do the search. You say, there's no gun. Let me go back to my testing. It's that creeping thought, that knowledge that there is still a gun on campus that leads to somebody saying, we probably still need to do something, but let's hold off. Every minute matters. Every minute matters. And they'll say, no, that's not what she thought. That's not what she knew, right? We had a time with Dr. Klinger, weapon, firearm. We'll talk about that in a second. The very first witness in this case, and it's sometimes hard to forget because it's a week ago. The very first witness in this case interviewed Dr. Parker within days in January of 2023 of this incident. And Dr. Parker herself said the students reported a gun in a backpack. You don't take my word for it. Take hers.
Let's get a break. We'll get more.
You have got to be shitting me. Did he just say to
from the
Parker herself, the very first witness in this case, interviewed Dr. Parker within days in January of 2023 of this incident. And Dr. Parker herself said the students reported a gun in a backpack. You don't take my word for it. Take hers.
Let's get a break. We'll get more from the closing arguments on behalf of the plaintiff when we return. And
fast forward, are underway in the civil trial connected to a lawsuit involving a former elementary school teacher.
Let's go back in the courtroom and pick up the closing argument on behalf of the plaintiff. We'll pick up where we left off.
Teddy? Southern's got another question. We got another hand in the air. Southern, why wasn't the mom called as soon as they heard what's possible? Good question. But we're going to do the mom as soon as we're done with this. This has a little bit more time. So I'm ready to get to the mom too. But let's finish this. Y'all, I want to know what, as soon as somebody said, hey, your kid's got a gun. I think your kid's got a weapon here at school. I'd have been like, oh wait, where's my weapon? And make sure, just out of the secureness of communication, maybe. I don't Southern, we're gonna find out, hopefully. And like I said, here, this is the civil trial. She was awarded the teacher was awarded 10 million. Now we're at a criminal where this woman may face years in jail.
At 12:20. And that at 1:40, there were still concerns of a weapon on campus. Her words.
12:20, she was told. And after one, y'all see, this is my problem. I'm gonna lose my shit. Look, ooh, girl, I need to do my nails. Ooh.
The school system as part of the investigation. Not my words. That means for an hour and 20 minutes. Hour and 20 minutes, and we still got another 20 before Miss Zwerner shot. There is a gun on campus. And they come up here with Dr. Klinger and say, well, she needs more information. What?
Okay, Denise, if you're driving home, let me know when you're home and I'll tell Ann hi, okay?
What do you need? You knew who. You knew what. You knew when. You knew where he was all day. You knew when he was in the classroom. You knew when he was on the playground. You knew when he was back in the classroom. What more do you need to act when a gun changes everything? And this is no time to play name games. This is no time for, well, maybe the child said bullets. Is bullets really a gun? Ladies and gentlemen, if you have an elementary school, 6-year-olds, if we looked at the classroom walls, we're still teaching them how to use punctuation correctly and what words to use and how to capitalize letters. And you're going to wait until a boy says, no, it was a gun. It was a real gun. It was black. It had bullets in the gun. No, ma'am. Gun, bullet, weapon, firearm. We don't need to talk about what all they mean. Each of them required a response. Each of them. But what we know for certain is that it was a gun from her herself.
She's shaking her head no, y'all. I'm watching her
2020.
body language.
Remember that? Hindsight 2020. It's easy to see now that there was a shooting, that we look backwards and now that we know there was a shooting. It's easy to know that looking at our rearview mirror. You don't need to look in the rearview mirror. There were road signs in front of Dr. Parker for an hour and a half, screaming at her, flashing at her,
red flashing
telling
light.
her exactly what was going to happen.
Y'all want rubber Ramada raw reaction? There was blinking fucking red lights in this woman's face, and she didn't pay attention. Okay, there you go.
And if she did not act, you do not need to look in the rearview mirror to know what's coming ahead. And the only reason it's in her rearview mirror is that she blew past the signs. She blew past the signs. Do we need every letter to know what it means? Do we need every letter? They're going to tell you this wasn't foreseeable. Remember that discussion? Wasn't foreseeable that this would happen. And that's why we talked about this question of foreseeability. And I'll show you an instruction on this. This is instruction 17. The defendant is not required to have anticipated or foreseen the precise injury, but it is sufficient that a reasonably prudent person would have anticipated or foreseen that some injury or damages might probably result from the negligent act. What does that mean? What that means is, and what they're going to try and argue to you is, who could have seen that a 6-year-old would pull out a gun from his pocket?
Okay, but wait. I like him, but guns don't walk into school. I will leave it at that. Guns do not walk into school.
What does that mean? What that means is, and what they're going to try and argue to you is, who could have seen that a 6-year-old would pull out a gun from his pocket, point it at a teacher, and shoot? That's not the question.
But nobody in their right mind would
the
think that would happen.
Question is for every moment, every minute, every second that a gun is in the possession of a 6-year-old who, I agree, has totally unpredictable behavior. if anybody has dealt with 6-year-olds, it's totally unpredictable. All the more reason to find the gun. All the more reason.
No,
That gun could have
no,
been
ma'am,
popping
no.
up and down in his jacket and gone off. Handed it to a friend and gone off. Showed it to a friend and a book hit it and gone off. Dropped on the floor and gone off. You do not have to foresee the precise injury that was caused. Only that some injury or damages might probably result. We can go to the...
All right, the closings continue. This is crucial because it's such a nuanced case. Franz Borkhardt watching along with us.
Along with Ted Rollins, thank you for following along. Civil.
After Zwerner behavior
that she first and
for 2.5 hours, this thing was beeping on her radar. Beeping. I use this as a
Good
metaphor
question,
to talk about what we just talked about. Because the focus here is a gun in a 6-year-old's
Everybody
hand.
tried to say
But I
something.
want you to think for a moment. Imagine there was a gun sitting right here on the playground at an elementary school. And a student comes up and says, there's a gun on the playground. Isn't the danger apparent just with a gun near the proximity of any of these agreeably unpredictable children?
Yeah.
Isn't that the danger? Because the gun is what changes everything. And you
It
may
was a
hear, well,
9
we don't know if it
millimeter.
was a real gun. We don't know. I think we heard from Dr. Klinger. Maybe it's kids talk about squirt guns all the time.
And 9mm is not a small gun, so
You really going to take that chance?
unless he's a big kid. I've seen some
Really
big
going to take
kids.
that chance? I have friends that like to play roulette. When they go up to the roulette table and they throw that ball and they put their chips on whatever color they want, you know what they've already decided? Win, lose, or draw, I'm indifferent. That money's gone. If I win, great, I'll have a great night. If I lose, I've already accepted the fact that I've lost. They are indifferent to the chips on the table. They are indifferent to the odds that are before them. And if you're willing to gamble on a real gun or a squirt gun at an elementary school, you are indifferent.
Right, Southern? That's what I'm saying.
To what
It was
happens
a
next.
9. So where was he hiding it that
You're going to hear from the other side. I'll point this out to you in an instruction. This question of gross negligence.
Oh, the mom's story is interesting. Y'all just wait. The mom's
instruction
story is
13.
interesting. Y'all hold on to your britches.
The degree of negligence which shows indifference to others that constitutes an utter disregard of caution, amounting to a complete neglect of safety of another person. Indifference. And the other thing that you'll find in your instructions, and I'll point this out to you, said, a gun changes everything. I've said it many times. I'll say it again. That first time, that first moment, not acting is indifference. Every minute is indifference. But even if it was just me trying to hit the apple instead of me trying to throw the ball at Jeffrey, even if it was not indifferent the first time, you follow? Even if the first time wasn't indifferent, what the law says is if I keep trying to throw the ball and hit Mr. Williamson, and every act of that attempt is its own negligence, those add up. And you start to wonder, what are you thinking?
Yes.
Why
yes,
do you
Cindy.
keep trying to throw the
That's
ball
Abigail.
and you're not getting the outcome
Her
that
up
you're
here in
trying
this
to
picture.
achieve? And so each minute, I said every minute matters, because each minute in which there's nothing done, in which the actions that she's supposed to take are not taken, in which she's not ensuring the safety of the people on that campus, each minute adds up. It adds up, even if each one of them on their own is an indifference. Go to the PowerPoint. Care is a verb. Care is a verb. What do I mean? It means that when you hear from the other side that she did something, she cared enough to acknowledge that there would be a search. She cared enough to say, well, we'll have a plan to search the boy when the mom gets here. That those acts of caring, those feelings of caring are enough. The response is, care in the law is not a feeling. Care in the law is a verb. It's an action. And the question is, what actions did she take in an effort to meet her obligation? Part 2, blame game. Real quick. This is the defense. Mistakes were made, but none by me. All right? Let's point the finger at all of these other people and say that they did the wrong thing. And I told you guys in voir dire, many of you might remember, I said, look, at the end of this case isn't about the parents. This case isn't about other people. The question is just going to be whether she was grossly negligent or not. And that doesn't deter them. They're pointing the finger at everyone that they can point the finger at to try and deflect responsibility and play the name game. And the issue with that is that each of those people that they're trying to point the finger at had a piece of the puzzle on January 6th. They all had an element of it, whether it was the backpack or whether it was the bullets or whether it was the shoot or whether it was the search. Each had a piece of the puzzle. But you know who had the entire puzzle? Dr. Parker. Dr. Parker. And what they're doing is that they're telling you that, well, these individuals should have investigated. Ms. Kovacs should have investigated. Ms. Zwerner should have pulled the kid out of class. Ms. West should have done something else at the parking lot. What the policies tell us in their agreements with each other in terms of how they're going to operate at the school is that those were all her job. And so what they're saying is Dr. Parker dropped the ball and they want somebody else to pick it up for her and do it. That's not right. And every time they come up here and say that XYZ person should have done something different, that Ms. Kovacs or maybe Mr. Rawls should have searched, just tilt that rear view mirror and look at it yourself. Because every finger that's pointed at somebody else by the other side of this case should really be a finger pointed at themselves in the mirror. What their job was, these staff members, was to be watchmen and to sound the alarm. And it was the job of administration within each of these policies to answer the call and to come and to do something about it. And each of them sounded the alarm. And they waited on the cavalry. And no one came. I told you I'd tell you about that moment where he said, hold on.
Oh, yeah.
Remember the moment Mr. Rawls says to Abby, hang tight. Hang tight, we're coming.
Hey, case one.
Every minute matters. And what Mrs. Zwerner should have seen coming through that door was the help that was promised to her. That we're coming. The cavalry is on the way. The first time Mrs. Zwerner saw a police officer on January 6th, 2023, should have been when they walked through that door, not when she was laying on her back in the administrator's office. Told you I'd pause. Pause. I don't want to rush through this. I'm going to try and be efficient, but I don't want to rush through this because it's so important. Costs and consequences. This is the part that we talked about in voir dire, and I said, how do we come to this number? How do we come to an amount of money? How is that done? And to some of you, I said, we'll go through it. I'll give you tools or I'll give you ideas and we'll talk about the law and we'll get you there. We'll make sure you understand what your job is and how to do it. And so with your permission, I'll start with a statement that I hope, I suspect, everyone agrees to. Everyone in this courtroom. Everyone in this courtroom. There is no material item, possession, object on this earth that is worth more than a human life. Not a single one. You're not supposed to watch the news, according to the judge. You can still watch the news. And last night I was watching the news, and I saw the news of a plane that crashed outside of Louisville, Kentucky. A UPS plane.
That's where my mental health part came in.
That the newscaster asked, how many lives were lost? He didn't ask, well, how much the plane cost? Or was it holding freight? Or what was the freight? Or what was in the plane? First question, and the first question that each of us thinks, whether it's in our gut, in our head, or out our mouth, is how many lives were lost? And that's because there isn't a single thing on this planet that is worth more than a human life. So we start there. And then the question is, how do we count the value of a human life? Well, over time, we've come up with phrases that we use every day. We use phrases like time is money. Heard that one? Time is money. We hear phrases that started in the 1600s and the 1700s that say, can I have a penny for your thoughts? Or, is it worth my time? All of these questions tell us that we understand that there is a value, a dollar sign, as weird as it seems to think about it, that we equate to our human experience, that we count in minutes, hours, days, weeks, months, years. And you heard it in this courtroom. We had experts take the stand, and they were asked, how much are you being paid for your time?
Yes.
Remember that?
Cindy.
$500 an hour.
This is the civil. This was the closing for the civil part, to where the teacher was awarded $10 million. Now, the criminal trial started today, and they did the voir dire. That's what we're going to get to.
Hour to be here.
All right, we're just about to get to the number. What is he going to ask this jury to come down?
Back into the courtroom now. We're still listening to the plaintiff's closing argument in front of this jury.
Dr. Klinger took the stand for about 2.5 hours, more than $1,000, sitting in this courtroom, talking about life experiences that she lived. And nobody blinked an eye. We understand, whether we ever think about it or not, that there is an equation, that we can equate human life and our experiences to dollars and cents. And it's my job to try and talk to you about that, and it's ultimately your job to decide how much it's worth. So, the jury instructions will tell you what I call what buckets or elements of damages to think about. And when I say that, I mean these 4 things right here. And we'll take them in order, and I'll tell you that I'm going to merge some of them. So we're first going to talk about bodily injuries, disfigurement, and deformity. The law says that if she is entitled to recover, that is, if Ms. Zwerner has proven her case, that she's entitled to recover money for each of these elements. So why did we put on the evidence? Why did we, if we can go back, put on the evidence of these 3 doctors and other doctors that came before you? Is to show you the injuries. To show you the injuries so that you could understand, based on the jury instruction, how bad, how severe, and duration, which is what the jury instruction says. How long will this be? And this is what we talked about. That a bullet pierced through her hand, into her rib, through her lung, and that it pooled. Remember that from Dr. Munn? That it pooled and it collapsed her lung, but that cavity is still.
And I believe she had to have 5 surgeries for correctiveness
in her body. And because that cavity is there and that bruising comes through, we talked about scar tissue. Like you pull a muscle and it never goes back to the way it's supposed to be. And it stays that way, and it affects the way that they can breathe. And it pierced through her hand. We had pictures of the fragments that were through the wrist. And we talked about the issues with the thumb and the index finger and the middle finger. And you heard Dr. Anderson tell you that this is the type of injury we see in war, that it's devastating. And that even though the bullet made its way through the hand and into her body, it still rests there today. And it still rests there today because it is 2 centimeters from her aorta. She was 2 centimeters from death. And that's never going to change. It's never going to change. It's there forever. And we talked about the surgeries that were done. And even to this day, she sits here with a piece of metal on her finger. Not because she did anything wrong, but because this bone still will not heal. And I will tell you, whether that bone heals or does not heal, we know for certain her wounds, all of them, will never go away. Don't we know that? Don't we know that even every moment she goes into the doctor's office and has concerns about what her medical condition might be, and she has to tell them, I've got a piece of metal 2 centimeters from my aorta, I can't have that test. I can't do that thing that I might need. And so when we talk about bodily injuries and their severity, and their duration. What we're talking about is how bad is it in the way that it affects somebody's life every day. And if you can't open a chip bag, and somebody might say on the other side, it's just a hand. It's just a hand. Is it? Is it when you return home from surgery in the hospital and you're with your mother, and we're talking about disfigurement and deformity, and you can't move your hand, and you can't bathe yourself at 25 years old? You can't use the restroom by yourself. Are we just talking about a hand? Or are we talking about what it is to have dignity and be a human being? The element of instruction talks about mental anguish. It talks about physical pain and mental anguish. But I'll tell you right now, physical pain, she felt more than anyone could ever imagine. I promise you that. And we showed you videos to try and tell you and show you exactly what it was like. But even when the pain goes away or goes down, this doesn't. This keeps going. And we heard from Dr. Watson, and we spent time talking about re-experiencing. Do you remember that? And I had a roadmap stop with Dr. Watson that said brain and body. Remember that? Brain and body. Why did we talk about brain and body? Because you don't injure part of a human being. You don't just injure a hand or an arm. You injure all of them. You change all of them. And what we heard about and what we talked about is a young woman at 25 years old, who had chosen her way of life, who had decided who she wanted to be, where she wanted to go, and the purpose that she would achieve. You heard from her sister that said she had a purpose. She knew what she wanted, and she was chasing it at 25 years old. And some may say, do you want to be a teacher? Really? That's what she wanted. Maybe it's because her mother did it. Maybe it's because she wanted it for herself. But that was her choice. And they'll talk to you about cosmetology school, like she had considered this beforehand. Really? Really? She chose to be a teacher, knowing full well from the experiences of her mother exactly what it meant. That it meant sitting with a printer next to you while you sat next to your sister and she watched movies. That it meant late nights, that it meant early mornings, that it meant difficult times with your students, that it meant being around them and shaping the future of our country. And I'm not saying that to you to tell you that being the teacher is the most valuable thing in the world. What I'm telling you is that it was her choice. It was her choice, and her choice to be what she wanted to be is changed and taken from her. What do we value that at? What do you value it at when you decide this is who you're going to be in life? And through no fault of your own, against your will, and without your consent, that's taken from you. That dimming of a light of a young woman who used to pop at you with color. That numbing.
All right, we'll get a break, but first, Rob Corbett watching along with us. He's in Charlotte, North Carolina. Your overall thoughts of the case and specifically
a former assistant principal and a former.
I probably have a really weird look on my face. I will tell y'all when we switched to do the defense closing, what just came across my phone that just kind of shocked me. But I'm gonna let them finish talking.
Elementary school teacher. That plaintiff's name is Abby Zwerner.
The multi-million-dollar lawsuit stems from a maternity.
That numbing of life's experiences. Numbing of it. What is that? That's not every couple months. I told you I would repeat this. Every minute matters.
I like
every
Cindy.
Minute matters. When you change a human being.
He's really putting it as hated as much as I. Okay. Let me just be the dumb housewife that people think I am. He's putting it in layman's terms where anybody can understand this. And make it simple or keep it simple, stupid. Isn't that what it is? Kiss, keep it simple, stupid. He's doing that. And by the way, I have Hector getting me a coffee. I told him, I said, since you're home, give me a coffee. I love my Hectorius.
When you change who they are and you rob them from the control to decide who they will be in the future, you've changed them forever. You've transformed that person. And the Abigail Zwerner that sits here in front of us today on this day, November 5th, 2025, is not the same Abigail Zwerner that walked into the classroom on January 6th, 2023. Does anybody have a doubt of that? It's not the same person. I'm not saying it's no one anymore. I'm not saying she's any less of who she was. What I'm telling you is that she's been changed and she didn't want to be changed. And what damages do you arrive at? What number do you arrive at for somebody who didn't want this and it's been inserted into her life like a bullet fragment against her spine? Every minute matters. I showed you the video of her laying. You know the video I'm talking about, right? Outside the office. I don't need to show you again, right? I don't need to show you again as she laid in the office and the color that her sister talked about in her face and the light that was in her life you could see was sucked out of her in that moment. And I asked her to step out of this room when we showed that video. I asked her to step out of the room because she doesn't need to see the video to know what that was like. That was her life. She lived it. And just like it might be burned in your memory.
During the trial, they made her step out to not have to relive the video. Oh, my little heart is going. Wow. Yeah, I was kind of getting that too, Southern, is that bullet can move. I mean, this is some serious shit. Whew.
Memories. Do you think it's not burned in hers? And when you think about moments of compensation, what is fair? The question that I asked you to determine is if in that moment, and if in that moment, someone came to Ms. Zwerner and said, Abby, this is what you're about to experience. This is what we're going to put you through. There's going to be a boy's face you'll never forget. It's going to come to you when you don't want it to.
Oh, bless her
And you're going to be
heart.
walking down a hall and you're going to be thinking you're on your way to heaven. And then for a moment, you're going to think you're not going there. Until you're shocked back to life with the pain and pressure of a colleague trying to save your life. If I stopped this case right there, if we stopped it in that moment in time, at 1:59 in the afternoon on January 6th, do you think that Abigail Zwerner would trade any amount of money and say, yeah, I'll go ahead and experience that? That moment that I thought I was not going to heaven, that my faith had failed me. I'll trade that for $10 million. Do you think she would trade it? She wouldn't. She wouldn't for a moment, but your job is the difficult one, which is to say how much would be fair in full if she had to take a trade. If a trade was forced upon her, what would be the fair amount of money? Because that's what's happened. It was forced upon her, and you have to decide how much would be close. And not just for that moment, but for the next, and the next, and the next. And the moments where she wakes up in the middle of the night, thinking of that exact moment, reliving it again, like it's playing on the screen in front of you and she doesn't need to see it. What is that worth? There are some holes. I told Ms. Toscano not to get too close to me, but it reminded me of something. We've all had that moment where you're getting a cold. You can feel it coming on, right? You can feel the tickle in your throat. And it's coming to you and you're thinking, tomorrow, probably not going to feel too good. My nose is going to start to run. Next day, I may have a cough. I'm going to stay away from people. Next day, I'm going to feel worse. My head's going to hurt. But what we have when we have those colds is that we know that one day will come, whether it's tomorrow, the next, or next week, that we're going to throw our legs off of our bed. We're going to sit at the end of it. And you're going to go, it's gone. I don't have it anymore. not with me. She will never have that moment. As much as she wishes to escape in her dreams and escape in real life, every time she throws her legs off the bed, that will be with her forever. And every time she sees somebody reach their hands in their pockets, which I've tried to be conscious of, will be picking a scab at a wound that will never heal. It is for all these reasons and for all of these moments that when you sat here a week ago, I asked you that we would be asking you for a verdict for $40 million. And if the evidence supported it, could you return the verdict? It is because she will never be the same. And somebody might say, that's a lot of money. It is a lot of money. I agree. But do you think for a moment she would trade it for what she's endured? If we could tell Abby to walk out that door right now, and her sister could look in her eyes and talk to her again, do you think she would trade it? This is the final thing I'm going to talk to you about. When you get back into that deliberation room, I want you to remember our conversation in jury selection. And I asked you about rendering a verdict based upon sympathy or not. Remember that conversation. And I said to you, it's not supposed to be based on sympathy for her, but it's also not supposed to be based on sympathy from Dr. Parker. Because when you go through this calculation and you decide what all of these harms and these losses and what's been taken from her is worth, it's not up to you to decide where the money comes from. It's up to you to decide what it's worth. What it's worth. And if you get back into that deliberation room and there's a conversation and somebody says, well, what effect will that have on Dr. Parker? Or how will she ever be able to pay it? And if for those reasons you reduced your verdict, the number might be correct. Whatever number it is that you decide in that moment might be correct. But it would be the right verdict for the wrong reasons. Because the only reason that you can reduce the amount of what it's worth to her is if you decide it's not worth as much as what we're asking. And that's a critical point because at the end of the day, what we want is a right verdict, but we want it for the right reasons. Because if it's full justice. Whatever full means to you, whatever you decide full is, that is full justice. And any centimeter or sip less than full justice is injustice. And injustice anywhere is a threat to justice everywhere. And so when you decide this case, when you analyze the facts, when you consider all the evidence, and you decide what's full and what's fair, I'm asking you, and I trust you, to render the right verdict for the right reasons. Thank you so much for your attention.
Okay, we have defense closing too. And oh shit, hang on, escape. It is, hang on. I think it says it's 47 minutes, but you know, we got to cut through some stuff. Okay, so let's go back. So Cindy asked the question, was the school board and others included in the lawsuit? And it comes back and says, yes, the school board and other administrators were originally included in the $40 million civil lawsuit filed by teacher Abby Zwerner, but they were later removed by the judge. When the lawsuit was initially filed in April 2023, it named multiple defendants: Newport News School Board, former Superintendent Dr. George Parker III, former Principal Brianna Foster Newton, and former Assistant Principal Ebony Parker. Here, I'll share this so y'all can see what I'm reading. Right. Where is this assistant principal going to get $10 million? But stop. Why were they taken out? So it's, and I have another question. This Dr. George Parker, and she was assistant principal. Her name is Dr. Ebony Parker. Are they related? I just me being nosy and asking questions. Just me being nosy. So attorneys for the school board superintendent and principal fought the litigation by arguing Zwerner's injuries fell strictly under Virginia's workers' compensation law, which would block her from suing them directly in civil court. Ultimately, a judge dismissed the school's district superintendent and school principal from the lawsuit. As a result of those dismissals, Ebony Parker was left as a sole defendant when the case proceeded to trial in November 2025, and a jury found Ebony liable for gross negligence, awarded Zwerner $10 million in damages. So, yeah, where's okay. All right, so let's see what the closing for the civil trial said, because it's going to be interesting to compare this with a criminal trial, because it's going to be a little different. So, and like I said, we'll go over the voir dire. We'll listen to the closing, and then we'll do the bomb. Okay, you think workman's comp will pay? They'll pay Ms. Zwerner? That's it. They should. They sure. It was on the job accident, right? So workman's comp should pay. All right, let's go listen to defense closings.
Paying attention to the evidence in this case. It's vital to our judicial system, and I want to thank you for that. I'm going to tell you what I'm not going to do today. I'm not going to talk about verbs. I'm not going to talk about puzzles. I'm not going to talk about rain. I'm not going to talk about plane crashes. I'm not going to talk about baseball. And I'm not going to talk about a Wheel of Fortune sign that has 2 tickets to paradise on it.
Ma'am.
I'm going to talk to you about the evidence that you've heard in this case.
Okay, sorry.
We're going to start here. You'll receive a jury instruction that says that you can't base your verdict on sympathy. And why do I say that? Because who here doesn't feel sympathy from Ms. Zwerner? No one. No one. We're not here to challenge that. But what this case is about, it's about real-time judgments in an elementary school on January 6, 2023. Real-time judgments, not hindsight judgments. It's about the likelihood that a 6-year-old little boy had access to a firearm, access to bullets, dropped off by his mom with a loaded firearm in his backpack, took a loaded firearm out of his backpack, aimed a loaded firearm at his teacher, pulled the trigger, and shot the teacher. It was unforeseeable, it was unthinkable, and it was unprecedented. And you heard many people tell you that, but we're going to start with this person. Who was that? Amy Klinger. She's a national school safety expert. She's written a book on school safety. And she came here and she told you the framework about how decisions are made among administrators and people in school systems. And we'll get to that later. But she told you, Mr. Beniozen talked about me blaming everyone else. But she told you that everyone involved was doing an analysis that day, but they did not perceive this to be a plausible imminent threat because it was a 6-year-old. It was unthinkable and certainly unprecedented. But now we're here. We're in the hindsight phase. Criticisms to find fault. 3 years later, with the outcome known, trenches have been dug. Somebody's got to go down. We're going to blame this person for it, Dr. Ebony Parker. She was the assistant principal at Rich Neck Elementary School.
Seek and you shall find. No, George Parker and Ebony Parker are not related. So there you go. Corrected.
On January 6, 2023. Talk about the issues in the trial, and I'm going to move past this quickly because Your Honor is giving you jury instructions. You're going to take the jury instructions back. and you'll see all the issues in this case. And I won't belabor this issue, but I'm going to tell you something. When you get back there, I want you to look at jury instruction number 16 about assuming a duty. And you're going to find, when you read that instruction and you apply it to the evidence in this case, that Dr. Parker did not have a legal duty to protect Ms. Zwerner. She did not volunteer to protect Ms. Zwerner. And you'll remember the admissions in the case that we read to you? These were Ms. Zwerner's admissions. She admitted that on January 6th, before the shooting occurred, she did not receive any communication from the defendant expressly promising or agreeing to protect her from risk of harm by JT. She admitted that before the shooting on January 6, 2023, she did not communicate to Dr. Parker that there was reason to believe that JT might possess a firearm. She admitted that on January 6, 2023, the only time she communicated directly with the defendant before the shooting was when she went to defendant's office and told her about JT's behavior during lunch. And she admitted that on January 6, 2023, before the shooting occurred, she did not receive any communication directly from Dr. Parker, the defendant, acknowledging that she knew that JT might possess a firearm. And even if you find there was an assumed duty to Ms. Zwerner by Dr. Parker, you have to find that she was grossly negligent. What's gross negligence? I love this definition. It's the absence of slight diligence or the want of even scant care. And you might ask yourself, what does that mean? It's indifference. Indifference. And the evidence in this case doesn't show indifference. Mr. Beniozen glossed over the evidence, but bear with me because we're going to walk through it. And indifference is not inadequacy. So what happened on January 6, 2023 at Rich Neck Elementary School? We'll start the day where it starts. The first person to receive communication about a potential firearm, Amy Kovac. Who was Amy Kovac? She was the reading specialist, 33 years of teaching experience, third on the chain of command in the crisis plan at Rich Neck Elementary School, worked with JT every day. So on January 6, 2023, Dr. Parker was working with Amy Kovac on winter growth assessment testing, that state standardized testing. There are specific rules that govern it. They were working together all day. Ms. Kovac told you she saw JT coming from lunch. He was happy, and he ran up to her and gave her a hug. She told JT, make good choices and make her proud. Then the two little girls came out of Mrs. Zwerner.
Y'all, I'm Usa. Okay. Right? I Cindy, thank you. I'm glad y'all are following. I mean, I'm not the only one watching this and seeing and going, what, excuse me? And I didn't even see the whole trial. We're just hearing closing arguments and what we've read in but on the news media so far. Well, I can't wait to get into this trial, y'all. I cannot wait.
Nurse room to the doorway and told her that JT had a gun in his bag. Ms. Kovac went straight into Ms. Werner's room, straight to JT, and told him what the little girl said. And she asked JT, can I have that bag? He said no. So she sat with JT for a while and asked him, do you have a gun in the bag? He said, no one's getting the bag. And she said, okay. She stayed in the classroom for 30 minutes, and made the decision to leave. She knew the child. What did she not do? Didn't follow up with the two little girls. Did not remove the backpack from the room. Did not remove JT from the room. Did not take JT down to administration. Did not evacuate the classroom. Did not call the guidance counselor.
Unmute your mic, dummy. It's okay, Cindy. I'm always behind. I try to make it on time. I try to be here. I try to do this. Something always interrupts. So it's okay. You can be as behind as you want to be. I love you just the same. We're in the closing of the defense. I know. Why was his mom called? Look at all this stuff. Didn't. And this was just with this one teacher.
Made a plan to check the backpack when they went to recess. went back to testing, and had discussions with Dr. Parker. So this is the knowledge that gets sent to Dr. Parker. Now here's the part where you've got to decide which Amy Kovac to believe. The Amy Kovac that told Dr. Parker it was a toy gun, or the Amy Kovac that told Dr. Parker it was a real gun. But her actions don't suggest she thought it was a real gun, do they? Which Amy Kovac? She testified in front of you. Her personal thought was it was a toy gun, and she had told that to HR shortly after the incident.
But it doesn't matter if it was a toy gun or a real gun. They should have been looked. It should have been looked at. Everything should have been. Stop. Hold the press. Everybody lock down. We're gonna make sure. I don't give a shit if this one thinks it might be a toy gun, a squirt gun. Oh my God. Do they not know what year this is? Do they not know this is 2026, right? I'm trying to look at my calendar, but my calendar says October 2025. I guess I need to change it.
But then she testified in front of you. She told Dr. Parker that the girls had reported to her that there was a possible gun. Which Amy Kovac to believe? Try this one. Amy Kovac's text to Dr. Parker 2 days after the incident. Look at this. Amy Kovac to Dr. Parker. You are an amazing person and educator. No one could have ever predicted this.
Out the gate, this defense starting with the other people who had knowledge outside of the assistant principal who is sitting at the defense table. Let's get to our break and we'll bring you more closing arguments. Zwerner should be in favor of the plaintiff or the defendant of a gun in the child.
Teacher will do in this situation. All did our best. We did what a true teacher will do in this situation. Be there for our children in school. As I look back, I should have sent JT out of the room with a note and a job to deliver it around the school. And I could have gotten that book bag, but I didn't. We can't look back. We can only move forward. I love you and I'm proud to work with you. But that Amy Kovac didn't come to trial. She sat here and she threw shade at Dr. Parker. She dissed her work and she threw shade, not this Amy Kovac. Remember that. Credibility. You'll get an instruction on credibility and you can use your common sense. You'll see the jury instruction. You're the judges of the facts, the credibility of the witness, and the weight of the evidence. Use your common sense in judging testimony. Think about this.
Hang my calendar back.
Who was the second person that day to hear about whether JT might have a weapon? It was Miss Werner. She was in the classroom when this went on with Miss Kovac. 30, 40 minutes, whatever it was. She sat here and she agreed that discipline is the initial responsibility of the teacher. She had dealt with misbehavior. How she dealt with student concerns was to first talk with the student. She told you she had taken a student by the hand, had removed a student from the classroom, and that was JT just 2 days before. He had thrown her phone, broken her screen protector, and she took him by the hand and she took him out of the classroom and brought him over to Miss.
Wait, what? Wait, he had a Ooh, woosah. Where's my duck? I need to squeeze a duck. Okay, all right. I knew I was missing something. I was missing my stress duck. What the fuck? Okay, y'all look. I'm fixing to get nasty. I know. I need to let them talk. But do y'all just understand? There was a confrontation between this teacher and child 2 days earlier. He threw her phone and broke her screen protector. And now we're like, when it was announced to anybody that this child may have a weapon, and we did what? Where did we? Well, I'm going to rewind this just a little bit because
testimony. Think about this. Who was the second person that day to hear about whether JT might have a weapon? It was Miss Werner. She was in the classroom.
Is not even
when this
the
went
right
on with
word.
Miss Kovac. 30, 40 minutes, whatever it was. She sat here and she agreed that discipline is the initial responsibility of the teacher. She had dealt with misbehavior. How she dealt with student concerns was to first talk with the student. She told you she had taken a student by the hand, had removed a student from the classroom, and that was JT just 2 days before. He had thrown her phone, broken her screen protector, and she took him by the hand and she took him out of the classroom and brought him over to Miss West's class across the hall. She also told you that she had a classroom phone to call the officer parents, and she had requested assistance from guidance before, had requested help on the walkie-talkie. Miss West across the hall had the walkie-talkie. And the same day that JT threw her phone, she went over with JT and had Ms. West get on the walkie-talkie and call Mr. Rawls to come and get them. So she knew how to remove him from the classroom. She also knew how to evacuate the classroom if she sensed danger. And remember, showed her the text. It's a year before. Ms. Zwerner herself tells her friend Rosalie List, another teacher at the school, that Q was at the office all day. I had to evacuate my room early for lunch. But on this day, she was in there when Ms. Kovac was there, loudly talking to JT about whether he had a gun in the backpack. She also told you in court that she had emailed Dr. Parker before. She had walked in and talked with Dr. Parker before. She had had guidance take students to Dr. Parker's office.
Right, Cindy? Oh, my God.
Remember that testimony? You'd go to Dr. Parker at times. You would email her. You'd walk in her office. And if necessary, you get guidance to take the student to Dr. Parker's office. Ms. Zwerner told you that she had discussions with Dr. Parker about JT's behavior during lunch, but not about a report of the gun. She had discussion with Amy Kovac in her classroom about the reports from the two little girls in her classroom. She had discussion with Amy Kovac in her classroom after Amy spent time with JT and did not search the backpack. She witnessed JT rummaging through the backpack. She witnessed JT put something in his pocket. And she observed JT at recess with hands in his pockets and R telling JT to keep his hands in his pockets. She had discussion with Jennifer West about that, the lead teacher with the walkie-talkie, and discussion with Amy Kovac at recess. But there are things she did not do. She did not follow up with the two little girls. She did not speak to JT, did not remove the backpack from the room, did not remove JT from the room, did not take JT down to administration, did not evacuate the classroom, did not call the guidance counselor, did not make use of the walkie-talkie, and did not call the parents of JT. Did not seek classroom coverage to personally discuss any of this with Dr. Ebony Parker. No visit, no call, no email. You'll get a jury instruction on contributory negligence. It is the failure to act as a reasonable person would have acted for her own safety under the circumstances of this case. Any negligence in Ms. Zwerner, which was a proximate cause of the accident, will bar her from recovering. Let's talk about other people involved that day. Jennifer West. You remember Ms. West? First grade teacher across the hall.
Right, Cindy.
She had the walkie. The classroom right across the hall from Ms. Werner's classroom was on the playground during recess with other first grade classes. Learned about JT on the playground and the discussions about him. I was informed that he took something from his backpack. I can't speak for sure if I was told it was a weapon. That's what she said in court.
We're hitting the pause button on these closing arguments so we can hit our break. First, let's check. On Monday.
Okay, we're going to palate cleanse for just a second because my anxiety, I did not know, geez, that it was going to go so bad. And wait, I know Denise is in vertical, but because she's home, I have to do this, y'all. It's an you need a cigarette? Girl, I'm trying to smoke. It's an interruption I have to do because it's a ritual for me. Are y'all ready? Here we go. Sheila's going big. Okay. Guess what? Hi, Ann. Good to see you. You got your woman home. You and Denise have a good time. And make sure you cook her something nice. Cook her something nice from Sheila. Okay? Put that little good kiss on it for me. All right. Okay. Let's go back to this insanity. Let's watch some Amazon for just a minute just to take a chill down because my duck, I'm kind of breaking his head off over here a little bit. Yeah.
Being recorded.
These are actually funny.
Because I'm Amazon.
I'm Amazon.
Amazon.
I adore you, Denise.
Pretty cool.
Do you hear this? Listen.
And black like me.
He's talking about his house, that guy's house. Listen.
I'm inviting you, so I invite you. Ouch! Fuck! I just
whole head, bitch. Hold up. Oh God, they're gonna go look back on the damn camera.
And he said, somebody gonna look back on that damn camera. He said, somebody gonna look back on that damn camera, and I would be that one. Y'all, I have I'm not even gonna lie. I have camera recordings of my niece singing, oh, Sheila out front in my camera. I have a camera recording of my sister-in-law falling and busting her face walking down the sidewalk of my house. Y'all, I have some great camera record. I'm not gonna put them out there, but I got some good shit.
3 of us here at one time. Is this a commercial?
And look, this is funny too, because look, let me see if I don't think I can back it up. But the Amazon driver and the UPS driver, and I think it's a FedEx driver, all showed up at the same time. And he said, we could make a commercial.
No, you're kidding.
I'm going to make it go back so it'll play that again.
You are currently being recorded. Hi. I currently don't care because I'm Amazon.
I'm Amazon.
Amazon.
What? Like your house. Pretty cool.
Bro, I like your house. And then he's walking away. He says, it's black.
And black like me.
Black like me.
I'm inviting you, so I invite you. Ouch!
And this is.
I just hit my whole head, bitch. Hold up.
Okay, I'll be quiet.
Oh,
Listen.
God, they're gonna go look back on the damn camera.
What the hell is this? All 3 of us here at one time. Is this a commercial?
No, you're kidding, bro. You're kidding, bro. This is my first time. Oh, you're kidding. I needed this today too, bro. You're kidding. Ooh. Oh my God. Dude, y'all are some G's. I'm starving. Y'all are so cool.
Look, watch. Listen.
No way that's a dog in there.
He heard dogs barking. He goes back to bark at the dogs.
Oh.
Hello.
Hi, how you doing?
We gon' fuck up the night. Let's do it.
This is cute too.
Oh, so sorry. I did not see. I thought that was a dog coming up on me.
Thought it was a dog coming up on me. Look at this one. He tries to get across the and then he goes back and he fixes it. This was so cute. This is me. I would go back and fix your flower bed. I really would. Here, let me straighten that out. I'll make it clean. I didn't mean to. I'm trying to carry the box.
Hi, you are currently being recorded.
Kind of guy. Oh, that's my kind of guy. Okay. All right. So let's go. Where were we? Let's see where these are closing arguments. Hang on. Defense closing. Here we go. All right. Okay. Enough crazy for a minute. And I will tell y'all real quick, the notification that I got on my phone that kind of made me look a little stressed, and this is breaking news, so take it as you will. Y'all know I don't like to mix things, but while we are here, I will stress y'all with a little bit of stress that I just read. All right. This was reported 1 hour ago. CDC issues travel restrictions for Congo Ebola outbreak. The CDC Department of Homeland Security has issued a travel restriction and enhanced screening measures in response to a fast-moving Ebola breakout in Central Africa, as an American doctor working in the affected area has tested positive for the virus. Under a 30-day order effective immediately, certain non-U.S. travelers who recently visited DRC, Uganda, and South Sudan are temporarily barred from entering the United States, and U.S. citizens are subject to enhanced airport screening but are not barred from entry. Outbreak has caused is caused by the Bundibugyo strain of Ebola, a rare variant with no approved vaccines or treatment. Nearly 400 suspected cases and over 100 deaths have been reported across the DRC and Uganda, with most cases concentrated in the Uturi province. The WHO declared the outbreak a public health emergency of international concern on May 16th. And it says the CDC says the overall risk to American public still does remain low. So that was a little concerning. So I just, breaking news. So we will put that out there. All right. So back to this. Now that we've all had a woosah and I broke my turtle's neck and we watched some Amazon driver, let's go watch this closing by the defense.
Let's get you back into the courtroom for these closing arguments. The defense talking about other people who should have known what this child may have done.
She said in court, she left the playground to deal with another student. Asked Ms. Zwerner to take her class back in the building. Remember, you're the judges of credibility. If you thought you were leaving a child on a playground with a gun, why would you say, why don't you shepherd your class and my class back in the building? Use your common sense. Ms. West encountered Dr. Parker in the hall. And so they'd come in and said Dr. Parker was indifferent. Dr. Parker was dealing with another student, Ms. West's student, and she didn't say anything to her about JT. Use your common sense. There was discussion with R about what JT showed him on the playground. We've heard about that. And Ms. West said, R told me, he said that JT had a gun and he saw it in the bullet. And I said, well, what color? Trying to see if it was real or not. And he said it was bullet color. In trial, Ms. West had one version of that story. She was asked, Ms. West, you testified that when you arrived on the playground, you weren't told specifically whether or not JT had a gun. Answer, that's what my note I wrote down notes that night, and that's what my notes say. But in her deposition, she had to admit she said something different. Your testimony under oath at the deposition preceding the trial was that Ms. Zwerner had reported to you the child did in fact have a firearm. Well, that's what I said then, yes. You're the judges of the credibility of these witnesses.
Case. Well,
John Sims, music teacher, covering phones in the office. The most important thing he told you, Ms. West didn't call him. He called her about another student, and that's when she mentioned what R had said. Now let's get to Mr. Rawls. Remember Mr. Rawls? Who was he? He was a guidance counselor. He was a member of the threat assessment team. He was part of JT's student success plan. Worked with him all the time. Very familiar with JT. And he told you he had some learning and some behavioral
Court audio is horrible. She just sounded like she was drowning.
issues. And JT had been taken to Dr. Parker's office on multiple occasions. And he, in fact, had been the one to take JT to the office too.
That's court audio just went out. That's not me.
West on her student that had eloped, that Dr. Parker was all involved in. So Dr. Parker, I think it's been said that she was sitting in there in her armchair. She wasn't sitting in her office on her armchair. She was working. She was dealing with other student needs. Ask yourself, does it make any sense that she would attend to that and blow off a gun in the school? Mr. Rawls said, I stumbled on some information about JT. No one called me. He's coming down the hall dealing with Miss West's student, and she tells him that R said something about ammunition or bullets. So Mr. Rawls spoke with R, and he did not interpret it to be a threat. It was a 6-year-old. 6-year-olds say things. Mr. Rawls, ever heard anything about a gun? No. You heard something about bullets? Yes. So at the time, you did not feel the need to remove JT from Ms. Werner's classroom? No, I did not. Later that day, or a little while later, Mr. Rawls had a discussion with Dr. Parker about the other student and about ammunition or bullets, and the bag already had been checked. He learned the book bag had been checked. And he discussed.
The book bag had been, I thought the book bag wasn't checked. See, now y'all are confusing me. This is why I need to see a whole jam trial. We're fixing to.
With Dr. Parker, checking the person. Dr. Parker looked at the clock, and said, why don't we wait for his mother to arrive? And he said he understood because he was 6. And so think of the context that was going on at this point. He'd been allowed, Ms. Kovac had investigated. She felt comfortable leaving the room. She felt comfortable not taking the backpack. She was not a young teacher. She was very experienced. She worked with this child every day. She knew this child, and she felt comfortable leaving that room. So that's a context. And then Ms. Zwerner didn't remove him from the room. And Mr. Ross told you he understood because it was a 6-year-old. And he didn't feel the need to go around Dr. Parker. He didn't feel the need to do that. It's a 6-year-old. Later in the day, Mr. Ross had gone back to his office. There was a lockdown, and he was coming down the hall. And he ran into some custodians. He didn't know there had been a shooting. And one of them said, they got him. And he said, got who? He told you he didn't have any idea who they were talking about. It was like, oh, it's JT. I knew it. I knew it. He didn't say that. He had no idea. And Mr. Ross told you that he went to his office and cried. You'll see that in the statement that HR had Dr. Parker write after, a couple days after. People hadn't lawyered up at that point. Maybe some of her language wasn't the best, but she told the story. She told that she cried too. They told the truth. No one saw this coming. Now let's talk about the experts in the case. Largely, their expert agrees with Dr. Klinger. Let's talk about it. And Shufflebarker. But let's first say, who is she? She's retired from the Virginia Beach Public Schools.
This woman really sounds like she's dogging every one of these people. She's like being really condescending and not very nice, in my humble opinion.
She's never been an expert before. She was introduced to the case through her sister-in-law, one of Ms. Werner's attorneys. She agreed that this was a rare event. She agreed that the assistant principal is not solely responsible for school safety, that it's a team approach. You remember the Q&A? You agree that it's unfair to judge someone's conduct with 20/20 hindsight vision? I can see that.
You know, so I find this interesting listening to this, and which y'all haven't listened to, but I have some of the questions during the voir dire of the criminals. So yeah, we're going to do a little comparison now that I'm listening to what's going on here.
You agree that Dr. Parker, in evaluating information regarding a 6-year-old having a loaded gun at school, something that had never happened to her, she didn't know the outcome of the day, correct?
Defense attorney Colleen Kelly still with us and weighing in on this case. PowerPoint sometimes, Colleen. I know update out of Tennessee in this trial, the broke my heart murder trial for defendant Latasha Daniels, charged with murder in the fatal shooting like bullets. And her defense claims that she initially bought the gun to protect herself better. Let's pick it up where we left off with the defense giving their closing to the jury.
He also agreed that school safety is a team approach. It's not just one person's job, and we'll get to that in a minute because Dr. Klinger made that clear to you and how that would be a terrible idea for it to be.
Well, we already know in advance the judge let the other 3 off, and she's all on her own. So maybe that's why there was Shufflebarger. Was she one of the ones? Let me see. Hang on. Let me look at the names. The school board, George Parker, and then former principal Brianna Foster Newton. So those weren't the ones she's talking about yet.
Each one person's job. She agreed that the teacher in the classroom is the first line responder about student behavior. She agreed that assistant principals must rely on other staff members and teachers in determining whether reports are credible. She agreed that searching a student is a judgment call based on a lot of factors. She also agreed that it's preferred that parents are present during body searches of little students. She also agreed.
Okay, if that's a fact, then that could have easily been done by calling JT's mommy.
Dr. Parker didn't refuse to search JT. She wanted to wait until his mother got there because the level of concern was not high. Mr. Rawls had said it wasn't a credible threat.
Don't get me singing, Cindy.
She agreed that age is a factor in determining whether to body search a 6-year-old. Age and a lot of other things are a factor, she told you. Sex of a student's a factor. She agreed that you want to handle the student with dignity and that there are legal rights to their privacy concerns in body searching children. Most importantly, she told you she worked 40 years in the Virginia Beach public school system. And she told you that that never happened. No child, no elementary child ever brought a gun to school.
Well, these are rare
Dr.
occasions
Schuffelberger also agreed
these
with
days.
agreed with me that Ms. Kovac and Ms. Zwerner were the first line responders to the reports about JT. She agreed that Ms. Kovac and Ms. Zwerner were in the classroom with JT after becoming aware of a potential weapon. She agreed that Ms. Kovac and Ms. Zwerner did not confiscate JT's backpack and that they did not remove JT from the classroom, and that Mr. Rawls had not determined there to be a credible threat when he spoke to Dr. Parker about JT. She agreed
Exactly,
that
Cindy.
other individuals did not stop what they were doing. She said she should have stopped what she was doing, Dr. Parker, but she agreed that no one else did. And as you recall, she didn't know the facts of the case. She told you that it was two teachers that came and talked to Dr. Parker about body searching JT. And on cross, I had to get out the truth that it wasn't actually two teachers. She then acknowledged it. It was actually the guidance counselor on the threat assessment team who worked with the child every day. Surely, if he thought at that point there was a credible threat to search this child, he would have done something. You saw Mr. Rawls. Anybody doubt for a minute that he wouldn't take action if he felt like he needed to? Now let's move to the defense expert.
And of course, they're
You
going
saw
to be,
Amy.
and I'll turn on my camera to say this because I'm smoking, so I got to turn my camera off. Their defense experts are awesome, and they're all going to be factual. And yeah, y'all know the drill. Okay, we're gonna let her talk.
Klinger, the defense expert. She has a doctor of education from the University of Toledo. She's a career educator and administrator.
She's a genius.
And now she works with school safety as a trainer and as a consultant. She founded the nonprofit called the
So can she train Miss Parker? I just asking for a friend.
Educator School Safety Network. She's a full tenured professor of educational administration. She's an instructor for FEMA and Homeland Security coursework. She has boots on the ground experience. She was a school principal from 1995 to 2008. She's researched, she's published, she's created training courses, and she's been an expert witness 25 times. Most of the time, she's against the school administrator.
25 times. So I
But she
told
came
y'all,
here
she's
and she wasn't against the
25
school
times.
administrator. She wasn't against Dr. Parker. She told you that Dr. Parker did not breach professional standards with respect to Ms. Zwerner on January 6, 2023. And she told you that Dr. Parker, it was her opinion that Dr. Parker was not indifferent to Ms. Zwerner on January 6, 2023.
Yep.
And she detailed how she came up with that opinion. She reviewed body-worn camera footage from the sheriff's department, including an interview with Ms. Kovac right after the incident. She reviewed the school board video interviews with people that were involved in the incident. She reviewed forensic interviews, witness statements, incident reports. She reviewed the protocols, and you're going to get an instruction about protocols. Protocols, you'll see, does not set the standard of care. But she reviewed them, and she told you that Dr. Parker didn't violate any protocols. She reviewed all the depositions taken in the case, and she reviewed JT's school records and his court records involving his mother. She reviewed all of that before she was willing to come and sit on the witness stand, swear to tell the truth, and give you her opinions in this case. Dr. Klinger told you that school safety is everyone's responsibility. It's a collaborative endeavor. School safety concerns do not occur in a vacuum. Every person in the school organization has roles and responsibilities related to school safety, every single person. A school administrator cannot establish the credibility of a potential threat alone. They cannot be everywhere, and they cannot see everything. She told you that it's important that the school administrator get information and disclosures from the people who are closest to the event. Dr. Klinger told you that discipline is the initial responsibility of the teacher. That's a standard nationwide. It's also in the Rich Neck Elementary School staff handbook that you've seen, and I think we'll go back to the jury room with you. Important to Dr. Klinger was the context of what else was going on and what Dr. Parker knew. That JT had been allowed to remain in the classroom and class instruction went on. The school day went on. The students went to recess. The first grade teacher discussed suspicious behavior on the playground, but they did not remove JT from the playground. Ms. Zwerner did not make any reports directly to Dr. Parker about a report that JT had a weapon.
We all have opinions, right? I mean, I am sitting here giving my opinion in my review of this, so we all have opinions. I mean, so yeah, and Southern, we have resource officers here. We actually in the Fort Bend County is one of the largest growing counties outside of Houston, which is HISD, Houston Independent School District. Fort Bend County ISD is a southwest suburb of Houston, and it is growing so fast. And we have police officers on campuses. We have metal detectors for schools. They don't play here. They don't play at all. So since when hey, I need English. Southern. I can usually read typos, but that one, baby, I don't know what you typed. Since when can a teacher to see? DISAE. I think is what that says. Is that an A? I'm trying to look for another A. Yeah, DIS. Since when can a teacher? Southern, help me out. Since when can a... Oh, good question, Southern. Okay. There you go. Good question. Since when can a teacher discipline a student? Never. You are sent to the principal's office, and it's the principal or the assistant principal that makes the decision to discipline a student. If I'm correct, I mean, geez, I'm only 54 years old, and that's the way we did things back then. And I don't think things have changed with the corporal punishment rules they got these days. I really don't think it's changed. I know, Southern, I'm just giving you shit. And I really didn't know what you said, but hey, we learned together. This is why I like the smaller chats, y'all. I'm not going to lie. I prefer these smaller chats. Yeah, it'll be nice, click that thumbs up. What does that go? Click the thumbs up, subscribe to the channel, all that YouTube-y stuff. I'm just here because I enjoy this shit, and I enjoy the small chat. I like that. I like that because I can interact with y'all very well, and I prefer to have a channel that is going to interact with me than somebody that has 50,000 subscribers and you're just another name that scrolls on a screen. So I appreciate you all for being here and spending your time with me in the duck pond. Okay. So yeah, I don't, for all my years, I don't think teachers can discipline the students. You have to send them to the principal or the assistant principal's office. Okay, let's roll.
And she explained why that matters. She talked about first line responders.
We are approaching the top of the hour, so we do have to get to our break. First, let's bring in for final thoughts.
So we are in Tennessee. Key test.
That what really matters.
Parker, let's go back in for more.
Oh, we changed. It's not, who is that girl? Janae. Something Janae. It wasn't Janae anymore. We got some blonde lady. Okay.
Mentioned it before, I want to mention again. And what she said is when an administrator is evaluating a threat, it's important to know what sort of actions are being taken so that what are the first line people doing regarding the credibility and the appropriate action to take for a response. And what she told you is that what really matters is plausibility and foreseeability. And she said when you're discussing a 6-year-old, it's much different conversation than if you're discussing a middle school or a high school student. This is a 6-year-old.
Really?
And she told you that when discussing a 6-year-old having access and ability to bring a weapon to school, clearly, we know at this point, it's unprecedented. That means it hadn't happened before. It was largely unthinkable and certainly unprecedented. Your job is to consider only what Dr. Parker knew at the time. And Dr. Klinger wasn't the only one that told you it was unforeseeable and unprecedented. Dr. Shuffleberger. She agreed that in evaluating information regarding a 6-year-old having a loaded gun on January 6, 2023, it was something that had never happened, and that Dr. Parker would not have known the outcome of the day. Ms. Zwerner herself told you that when she saw the gun for the first time that day, when it was unfortunately pointed at her, that she was shocked because she didn't expect to see a real gun. And she had been in the classroom with this child and on the playground with this child. Amy Kovac said it too.
That?
Who would believe that a 6-year-old would bring a gun to school premeditated to shoot his teacher? Mr. Rawl said it. He talked about hindsight bias and feeling regret about what happened. But let's look at what Corporal Blythe said. He was one of the first responders, the sheriff. What did he say? We were quite taken aback. We didn't expect to see such a young suspect. It was unforeseeable, it was unthinkable, and it was unprecedented. I submit to you that Dr. Parker did not assume a duty of care to Ms. Zwerner. She did not breach a duty of care.
Ma'am, if you gave me this picture and you told me to describe what this picture means, I'll pause here for anybody on the replay crew. If you put in the comment below, if you see this picture in one of those I see pictures, and let me explain to you what this picture means. What would this picture mean to you? Faults and damages are on either side of a brick wall. I mean, well, back in my day when I was in school, what happened was the teacher you got sent to the office and there was a sad note sent home, or you got pops by the principal. And I always chose the sad note because my principal was a big man and I was so scared of him. Oh my God, what a crazy thought. Even to think about him this day. So I got the sad note sent home. And then, of course, when you get the sad note sent home, then your mom's jerking you around by your shirt and spanking your ass. And, you get the punishment from your parents, but we didn't get it from the school. I mean, you had to have there was a form that you had to sign for the principal to give you pops. And my parents never signed the form, but I was a good child and never got in trouble, except that one time because my best friend, hey y'all, remember my best friend that I went to lunch with a couple weeks back? Well, it was me and her. We got in trouble. We were in 2nd grade and she told me to write nasty things about her sister on a piece of paper, and I did. And she read it and she threw it in the trash. Some bitch got it out the trash and gave it to the teacher and had my handwriting with dirty words in 2nd grade. I got in trouble. Well, my mama, she wanted to know, why would you say that about Heather? Why would you? I said, because Heather's a bitch, Mom. That's what we all decided. Anyways, I got in trouble. But I got in trouble by Mom. And it was a day of ballet. So I had on my ballet outfit. And she was jerking. I was so worried about her stretching my ballet outfit out. Anyways, so total squirrel side rail. Sorry about the squirrel moment there. But y'all know that happens in my life. We have squirrel moments. So anyways, back to this picture. Fault, brick wall, damages. I wouldn't be able to figure out what this picture meant if you were giving it to me in one of those, tell me what this means. That's where I was going with this. Let me see what y'all were saying in chat. That's BS. I got in trouble for defending myself too. Boy committed battery at least. Yeah. Cindy's granddaughter getting suspended. Who's at fault and what are the damages? Okay, that's what you get out of that. Who's at fault and what are the damages? But what's the brick wall mean? I don't know what the brick wall means. I mean, we're going to break this brick wall down and I don't know. Okay, we'll run with Cindy's idea. Who's at fault and who's damages? Cindy might have watched this, damn it.
And that she was not grossly negligent. I submit to you that Dr. Parker did not assume a duty of care to Ms. Zwerner. She did not breach a duty of care, and that she was not grossly negligent. And it stops there. And you don't even get to damages. However, I need to talk to you a little bit about damages, and I'm going to tell you why. As you may recall, I questioned some of Ms. Zwerner's witnesses about her damages. And there was a reason I did that. Ms. Zwerner has come to this court asking for $40 million from Dr. Parker. And she told you that she cannot even open a bag of potato chips. And her counsel, he repeated that today. As an officer of the court, and as my ethical duty to Dr. Parker, it's my job.
What is that icon, Cindy? I don't know. What the? I can't figure out the icon. Cindy, I can't figure out the icon. I can't make it bigger.
Unpleasant as it is to come in and tell you there's a different side to that story. I'm an officer of the court.
It doesn't, do you see, it's a brick wall, but do you see when I pop it up here? When I pop it up here on the screen, that doesn't look like a brick wall. But now if I go over to the live stream that you're in and I look at it through YouTube, it looks like a brick wall. So that's insane. See how StreamYard just misled me, damn it.
And so I questioned Ms. Zwerner and some of her witnesses about the fact that she has gone to cosmetology school, passed with flying colors, and is a licensed cosmetologist. And some of her witnesses have come in and said she only wanted to be a teacher, but I've shown you, if I'm admitted into evidence, are the texts that shows there's another side to that story too. And the other side to that story is that it was something, teaching was hard. And I'm not saying that to cast any blame on Ms. Zwerner, but to say she had thought about going to cosmetology school for years. So to come into the court and say, I only wanted to be a teacher, that's all I ever wanted, and now I can't, even though I don't think anyone testified she couldn't, I need $40 million. It's my job to tell you there's another side to that story. Ms. Zwerner and some of her family members have said that she can't leave her house. She's become reclusive, that she's withdrawn from the community. And again, I have to show you, when someone's asking $40 million from Dr. Parker, I have no choice but to say there's a
statement from Dr. Parker is an inappropriate statement of law.
Say that again.
The statement from Dr. Parker is contrary to the jury instruction.
I didn't think
assess the damage.
I don't think she said anything that Dr. Parker said.
No, I could not.
I didn't hear that.
Stated from Dr. Parker was counsel's argument.
All right, you overruled. You may proceed.
I showed you the social media posts that Ms. Zwerner produced in discovery. She produced them to us. Flip through them. She's reaching out to international celebrities to go to the concert 9 months after the shooting. Again, officer of the court, duty to my client, I have to tell you the other side. It's my job. And that's why we brought you Dr. Hagan. Dr. Hagan explained to you what a forensic evaluator does when determining whether someone has PTSD. Dr. Watson came, as eloquent as he was not Ms. Zwerner's treating healthcare provider. He was a retained expert paid for by the plaintiff to talk about her damages. But he did not look at her treatment records from before the shooting. He did not see that there had been diagnosis of PTSD before. And Ms. Zwerner herself, the last question exchange we had, she had to admit that she had not been truthful with Dr. Watson. I'm not minimizing what happened to Ms. Zwerner. I'm not doing that.
You sound like you are, ma'am.
I have to bring the truth and the whole story. It's the brutal honesty that Mr. Beniozen stood up when we selected this jury and told you he wanted. I have to do it. This case has been a long road for a lot of people. Mr. Beniozen glossed over the evidence in the case, and I want to thank you for listening to me as I went point by point what happened at Richmond Elementary School on January 6th. I went through the evidence. You heard the testimony. You weigh the credibility. These are the facts. And I would submit to you that when you go back and you consider the facts and the jury instructions that the court gave you, I would ask that you find that Dr. Parker did not assume a duty to Ms. Zwerner. She did not breach a duty to Ms. Zwerner, and she most certainly was not grossly negligent or indifferent to Ms. Zwerner.
Okay. Well, well, no, we're going to do this instead. Wait, where is it? Here it is. Okay. All right. So what we're going to do is we're going to move me to the back. So y'all are here. We'll put me up here. So this is JT's mother. Remember, we were wondering what happened to mom, what happened, all that. Well, this is it. Mother of the 6-year-old who shot his teacher, sentenced to 2 years of prison for child neglect. And there's the mommy. There's the beautiful mom. So her name is Deja Taylor, the mother of Virginia's 6-year-old who shot his first grade teacher in January, was sentenced Friday to 2 years in prison, according to the court in Newport News. Deja Taylor had pled guilty to a state charge of felony child neglect in August. Taylor's attorney, James Ellison, told CNN the Commonwealth had recommended a 6-month sentence. Yes, 6 months. Recommended a 6-month sentence. He says they do not plan to appeal the state sentence. I think it's excessive and harsh, Ellison said about the sentence from Circuit Court Judge Christopher Papile. In addition to the 2-year sentence, Taylor is serving 21 months for 2 federal felony charges: the unlawful use of a controlled substance while possessing a firearm and making a false statement while purchasing the firearm. Ellison says he believes the judge wanted the sentence to reflect the child neglect charge was a more serious one than the federal charge. Taylor was very upset when the sentence was given Friday and cried out in court, according to Ellison. Taylor's son, who is now 7, used her gun to shoot his teacher, Abigail Zwerner, on January 6th at Richneck Elementary in the Newport News, leaving her with wounds to her hands and chest. So the teacher read a comment in court. So Zwerner was present at Friday's sentence and recounted the shooting and her long road to recovery in the same emotional victim statement she had previously read at Taylor's federal sentencing. The boy pointed the gun directly at me and shot. The single bullet went through my left hand and lodged into my upper left chest, leaving traces of bullet fragments in both areas that will remain forever, Zwerner said. And when this happened, an emergency responder worked to keep me alive. I was not sure whether it would be my final moment on earth. Zwerner's filed a $40 million lawsuit alleging Newport News public schools ignored warning signs and were aware the history of random violence. The school board moved to dismiss the suit, but a judge said it could move forward. So Zwerner noted she's had 5 surgeries and many physical therapy appointments to restore movement to her hand. She also described she stressed the shooting has had on her family, who's had to help care for her, as well as the financial toll is taken in the form of medical care. I lost myself following the shooting. I could barely communicate with the loss of my friends and family, Zwerner said. This permanent damage should never have been allowed to happen to me and would not have happened if not for the defendant's action or lack thereof. Taylor had purchased the gun used in the shooting and kept it on the top shelf of her bedroom closet, secured by a trigger lock, Ellison told CNN in January. But in their search of Taylor's residence, authorities found no trigger lock and no key to a trigger lock, prosecutors said in court in August. Taylor has no criminal record and has cooperated with authorities since the shooting, her defense attorney said. In a May interview, the mother The mother accepted responsibility and whoa, let's see if we can find this. Nope, it's not here. And it's not here. But that's interesting. I found that very interesting. Hang on, I got to take this down and reshare it because it lost. Okay. So I'm going to start it right here, which this is, yeah, I know what the ever loving hell. But wait, y'all, this is good news here. Wait. So following her okay, so she received a 21-month federal sentence which she served. Following her release, Taylor faces 2 years of probation, which requires mandatory substance abuse and mental health treatment along with parenting classes. So, yeah, and as of right now, she was released from state custody on May 13th, 2026. Firearm was not secured because there was no lock. They searched her house, found no lock, found no key, and that's all the time they gave her. I don't get it. I don't get it. I mean, I'm just, I don't get it. I don't get it. But that is our court.
I'm going to get started with my opening remarks, but I just wanted to let you all know we will try to take frequent breaks for many years. Incapacitated.
Why can I not hear this? Is this my headphone or is it? Does she sound low to y'all? She's real low. I gotta find another stream of this.
Ten, 11, 12, 13. 14, the court that is
22-371.1 subsection B of the Code of Virginia as amended. How do you plead?
Use and identify yourself by your number. That's for.
Can y'all hear that?
And it's part of best practices. So I don't want anybody to feel disrespected because I'm not referring to you by your names. I know you all have full names, but we use numbers again for the press coverage and best practices for.
This was the one with better sound, I think.
Do we need to get medical attention for it?
She said it was just difficult for her to breathe while in there, so, let's find out.
Okay, just bring, just number 15.
Okay, this is our lovely defendant. This is Ebony Parker. This is who we will be watching for the next few days. Yeah, I know. I was trying to see if I can. I don't have a sound booster right now because I had to delete a lot of stuff.
You may be seated. All jurors present.
And to the attorneys, we returned from lunch break. The jurors are here. Do you wish to have them take attendance by number or just do a head count? I believe we should have 68 people.
Oh, this was the one. Hang on. I have it in my. Let me come over here and get it. Because I have it. I have it in my YouTube. I watched it earlier. And I could hear everything, so that's not. Okay.
in the current term of this court that is expected to be tried.
We're just gonna have to turn it up because that's the yeah. Yeah, we're just gonna have to turn it up because it's not letting me it's not letting me boost the volume any. So I'm sorry. But I will turn on closed caption.
By a jury. No. Were any of you present during the prior 3?
You back it up.
Anyone else? All right, this is a worded question. Have any of you been called and reported to any state court for either civil or criminal jury at any time during the prior 3 years, prior to being summoned to serve on this jury? So has anyone served in the jury in the past 3 years? No. Okay, by law, we try to give you a 3-year break between being called to terms, okay? Have any of you been adjudicated as incapacitated by any court? No. Do any of you have a case pending in the current term of this court that is expected to be tried by a jury? No. Were any of you present when the grand jury was instructed on the first day of the term during which these indictments were handed down? No. Do any of you have a hearing impairment not corrected by hearing aids? No. Okay, I'm going to go a step further. Is everyone able to hear me? Yes. Is there anyone who's having any trouble hearing me? No. And as we go on throughout the proceedings, because different people will speak from different points in the courtroom, if you have a hearing issue, let us know and we'll do our best to fix it. Do any of you all have a sight impairment, a vision impairment, which is not corrected by lenses? No. Okay. Does any?
Cindy's playing along. We're gonna be voir dired right now. See if we can make this jury panel or not. Okay, y'all ready?
Anyone have any medical condition that would prevent them from sitting on this jury? No. Okay, yes, ma'am. Give me your number, please. 15. Are you able to stand? Yes. Please do. Okay. And is it something that you're okay stating publicly? No. Or do you want to answer privately? Yes. Okay, we'll mark you down and we'll take you down. You can have a seat. Thank you.
Y'all, my thoughts are bad. I need to stop. Get hemorrhoids for sitting too long sometimes. She sounded old. Sorry.
Again, as I mentioned earlier, the trial of this case is expected to take 4 days.
Yeah, no, the jury is all in there's 80 people there, I think. And she's asking them questions and the lawyers are going to come in and ask questions too. So yes, we're the hidden jury. We're all hiding back here because we're going to follow this shit. I am so invested. I need to know now. Now I need to know because this is so.
Any of you have pressing business that will prevent you.
Yeah, and it says it's expected to last 4 days. So we're here. We're here for the party.
From giving your full attention to this case for 4 days. Okay? Yes. Number 11. I can see you, number 11. Anybody else? Okay, hold on. We've got number 11. Number 73.
I can be here for 4 days.
Today, and who knows where they are, but I'll try to have them tomorrow.
Teresa, you can be here for 4 days. You be quiet.
And 75 and 34. And I'm going to get back to you. I'm just marking it down. And 47. Oh, okay.
Me too, Cindy.
I got 73. Okay, thank you. Okay, well,
I'm sitting in my comfy pillow.
Yes, sir. And you stand, please.
I have religious observance on Friday. It's a holiday.
Okay.
Oh, Friday's a holiday.
Notified the court and received a excuse.
It's a religious holiday, Friday?
All right, thank you, sir. Okay, and number 34, juror number 34. Yes, sir.
I have a graduation I'm going to on the 28th.
28th of this month?
Yeah, ma'am.
Okay, thank you.
She said 4 days. That shouldn't interfere.
All right, and juror number 47.
I have it turned up loud in my ear so I can hear what they're saying.
All right, juror number 73.
Isn't that Monday? Next
My
Monday.
family has reservations to go out of town on Friday for the holiday.
Monday is a holiday, I thought.
Thank you. And juror number 75.
I've been summoned as a witness for another court case on the 20th, and on the 25th, I gotta go to a music festival.
This cracked me up earlier. This cracked me up. He's got to go to a music festival too. He's been summoned as a witness for something else, y'all. But he has a music festival to go to. I'm going to back him up. 75's out of there. We know 75's gone.
I've been summoned as a witness for another court case on the 20th, and on the 25th, I gotta go to a music festival.
Okay, so you're summoned as a witness in another court case on the 20th. So that's Wednesday of this week.
Yes, ma'am.
Okay, and where is that? I mean, like what city? Here in the corner. Okay, thank you. Okay, is there anybody else who wanted to give an answer to that question that I did not call? Okay. And Ms. Parker, if you please stand, I'm gonna ask if anybody's related to you.
Uh-oh.
All right, Ms. Parker is the defendant in this case. Are any of you related by blood or marriage to Ms. Parker? No. All right, does anyone know Ms. Parker? No. Thank you, Dan. And come over as somebody, you do, okay, number 70. Okay.
Somebody said, right? He probably has some like, probably has like a wild ass rock band. They're in trouble. Y'all, I'm just making shit up. And they're all in trouble and they have to go to court, but they're going to be playing Friday night. But listen, number 70's got a problem. Number 70's got a problem.
Stand up, thank you for me. If you can stand, please. Okay, yes, ma'am.
She's in my sorority.
Okay.
She's in my sorority. How old are these women?
I'll mark that down. Thank you very much. All right, and any numbers that I may have missed on that question of related by blood of marriage or no, Ms. Parker? All right, no additional answers. The Commonwealth will ask you about their witnesses. Have any of you had any business dealings or an employee-employer relationship with Ms. Parker? No. Do any of you have any interest at all in the trial or outcome of this case? No. Have any of you, yes, we have, okay, juror number 79, thank you.
79. Wait, 79. He's got some interest in the outcome. Right? Hey, Sword Sister. What's up? I ain't seen you in a long time. What the fuck? Hang on. Babe, you gotta do something. That sounds like some funeral music on that TV. It's not relaxing. Please. I'm about to go crazy. I can hear it. Nobody else can hear it, but I can hear it.
Okay, to which question?
The last one.
Okay, business dealings?
No.
Oh, the interest in trial, interest in the case. Okay, juror number 79, yes, ma'am.
Friends with the teacher that was involved.
Okay.
She was friends with the teacher involved. Stop. Yep, she's out.
Okay, thank you very much. Okay, and
Right.
it's number 58. Please stand. Yes, ma'am.
Uh-oh.
I don't know if this is a conflict, but I believe I work for the same school district.
Okay, you work for the Newport News Public School Systems. Okay, thank you.
Yeah, she'll be gone. They'll kick her.
All right, and, okay, number 8. Yes, ma'am.
If that is a conflict, I also work for the same school district.
Okay. Thank you. And anyone else? Okay. Hold on. I saw a hand raised, but not a number. In the pink shirt. Ma'am, in the pink. You didn't?
No,
Okay, not you.
there's two back here.
Okay, thank you. Let me know. 61. Yes, ma'am.
I'm married to someone who works in the administration for Newport News.
Okay. Thank you. All right, and there was one more number, and that's 59. Yes, please.
My daughter-in-law is principal in Newport News and went to that school the following year after this incident occurred.
Thank you very much. Juror number 59. Okay, I saw number, okay, number 20. I'll get back with you. Let me record her response. Okay, juror number 20. Yes, ma'am.
I don't know if I'm a teacher for Newport News Schools.
Thank you very much.
Yep, all these that are employees, family, teacher, they're cut.
Oh. I have another, okay, 69. Thank you, juror number 69. Yes, ma'am.
It does affect that my sister I live with is a teacher in the district.
Okay, and who, your sister? Okay, thank you.
She lives with her sister and she's a teacher in the district. Okay.
Okay, I'm coming. Number 17, 74 and 7, you're number 17? Okay, yes, ma'am. Okay.
That's what they all do. This
And
just
for
must be a school
74?
district.
My aunt works for Newport News District for all the schools.
Okay, thank you.
Must be like one of the only other things besides working at a hospital to do there. I don't know. Must
I'm
be a
sure
small
the attorneys
town.
will have some follow-up questions, so I'll take, we have 80 and 77. So let me start with 80. Yes, ma'am.
My aunt is a Newport News teacher.
Okay, thank you. And 77, juror number 77.
My mother's an employee for the Newport News School District as well.
Okay, thank you. Any other numbers? All right. Have any of you expressed or formed any opinion as to the guilt or innocence
Yes.
of the defendant,
Damn.
Ms. Parker?
I'm out already.
The Commonwealth today is being
No,
represented
I'll be
by
fair.
Attorney Joshua Jenkins or Josh Jenkins? What's your preferred?
Josh Jenkins.
Josh Jenkins. And
I'll be
he's,
fair.
presenting himself to you. And
I'll
then
try.
Ms. Jenkins. And then the defendant is being represented by Mr. Curtis Rogers and Mr. Stephen T. All right, thank you, gentlemen. You can have a seat. Have any of you been represented by the attorney who represents the Commonwealth? So the first gentleman who stood, have any of you all been represented by him?
No.
Have any of you been represented by the attorneys for the defendant, Mr. Rogers and Mr. T?
No.
Okay, but I have a number. Yeah, give me a number. 17? Okay, yes. Who do you know? Who have you been represented by? Okay. Thank you. You can have a seat.
Well, she's out. Wonder what she was representing. He's a defense attorney. Wonder what she
Anyone
did.
else who's been represented by the attorneys in this case?
Because you know, if she was represented by a defense attorney, she did something. Yeah, right. How many of them are lying to get out of
You
there?
feel the need to list the
Right,
attorneys that are
Southern.
in your office?
I can do that, Judge.
Okay, if you would wish, please do so.
I'm going to read a list of names of attorneys, and at the end, I will simply ask you to show your number if you recognize any of the names.
Right, Cindy.
Anton Bell, Karen Rucker, Paige Buffington, Amanda Winchester, Pia Miller, Faith Laney, Emily Huff, Mackenzie Butler, Mary Button, Emma Cleary, Amy Cross, Angela Davis, Alberto Guerrero, Lynette Hill, Haley Lieberman, Raelle McClure, Molly Newton, Jennifer Truitt, or Ryan Serby. Please raise your number if you recognize any of those.
I don't know any of those people.
Okay, and we're gonna go in order, so just hold it up till I get to you. I saw number 14, you're number 14. And which name did you recognize?
It's got to be a small
what's
town.
your
I
connection?
gotta look. I'm gonna see how small this town is.
Okay, thank you. Okay, anyone else in this section right here? Okay, and I see you over there, I'm gonna go to this section to my right, your left. Kathy, number 49. Okay, juror 49, which name did you recognize?
Anton Bell, Karen Rucker, former paralegal for the Hampton Commonwealth Attorney's Office.
Okay, thank you, juror number 49. Okay, anyone else in the section to my right? Okay, now I'm gonna move to the section to my left, okay? Juror number 71, yes, sir.
Your Honor, I recognize the name Molly Newton.
Okay,
And I had served in public office, and Ms. Newton had come to my office to interview for a possible position on that sheet.
okay, thank you, sir. Thank you, juror number 71.
Well, here we go. Here we go for an interesting break. Let's see. So it's an independent coastal city in Virginia with a rich maritime history located on the northern shore of the James River and Chesapeake Bay, forms a core part of the Hampton Roads metropolitan area. There's museums there. There's military and shipping industries. And this is what I wanted to know. City's population is estimated at 181,558 residents, and it stands as the 5th or 6th most populous city in Virginia. Its population experienced a slight downward trend, declining at a roughly 0.4% annually. And it says that there was problems with the fact that there is not only this shooting, but there was another shooting. Hang on, let me go back up here. Recent years, it's drawn national attention due to institutional struggles within the Newport News Public Schools following a string of safety incidents, including a 2021 shooting at Heritage High School and the high-profile January 2023 classroom shooting of teacher Abby Zwerner. So, yeah.
You must question everything.
Okay, there was another number, 83. Yes, juror number 83. Whom did you recognize?
I recognize Mary Button, but I'm not comfortable stating where I know her from.
Okay.
She recognizes someone, but she's not comfortable telling you where she come from, where she knows her from. That's a hush-hush deal. Now I have more questions. And she just got kicked.
Thank you. Okay. Any other numbers raised in the last section? Okay. And Mr. Rogers, Mr. Chief, do you wish to list any associates and for the jurors today?
No, ma'am, we don't have any associates, but under the abundance of caution, should we have Mr. Jenkins list the names of the office that he previously worked in?
Cindy!
Mr. James, your response to that?
I think the whole point of being appointed as a special.
Dollar bill.
But if you want me to read the names, I can.
I concur, right? I think Nancy, you've listed your office and Nancy Cumberland's attorney's office. All right.
I need Hio's pizza. We need pizza.
And Mr. Jenkins, do you have all of your witnesses here?
They're not here due to them being scheduled out, but I do have a list of the names.
Okay, so I'm going to ask him to call the names of his witnesses to see if anyone recognizes them. Please do so, sir.
And Judge.
Shh, don't tell her I stole it.
Correct me if I'm wrong, but I think we're looking for anyone who knows this person personally as opposed to just recognizes the name from a public statement.
Oh, yes, sir. So if you phrase your question that way, please.
Yes, so I'll read a list of names, and at the end, we'll ask you if you know or have interacted with this person personally. You may have recognized the name, but did you interact personally, will be the question. The names are as follows: Abigail Zwerner, Amy Kovac, Deputy Briggs of Newport News Sheriff's Department, Deputy Blythe of Newport News Sheriff's Department.
Girl, I have missed you. Who's there? She even put a door up. Look, the world stops. La Maresta Maria came. How are you, honey? I know we're like right in the middle, but I'll stop for you. Who's there? There you go. Note. Note who? Oh, not the day goes by without thinking of you. Girl, I've missed you. I hope you're doing well. You know, I was just saying that earlier. I enjoy my little chat, the fact that I have my small and we're able to, everybody is able to communicate amongst each other and stuff. I love that. So I know we miss you. We haven't seen you in so long. How's school? How's everything going? I'm going to hit play and let this guy continue to talk, but y'all just tap away in that chat. And thank you for coming to the duck pond and hanging out with us where we let shit flow off our back. Don't bring your dirty feet in here. Make sure they are in the water and they're perfectly clean. So with that, I'm going to hit play.
Brianna Foster, Mia Oliveria, Rolando Russ, Rolanzo Rawls, John Sims, Jennifer West, Susan White, Nina Farish, Jessica
That's
Stevens,
awesome.
Megan DeLeon, Nicholas DeLeon, Mark Garcia, Hynesia
Proud of
Richardson,
you.
Alicia Thompson, Kelly Wells of NNPD, Newport News Police Department, Sean Amadeo of Newport News Police Department, Stacy Husterberg of Newport News Police Department, and Aaron Thornton of Newport News Police Department. Also Brittany Gregory, Ramon Gonzalez Hernandez, Sarah Gonzalez. So anyone who knows personally or has spoken personally.
We have juror number 79. Okay, yes, juror number 79, and I know you did previously say you were friends with the teacher. Okay, all right, but no other person. All right, thank you.
In Suma, they were the shining one.
All right, no other numbers presented for that response.
In Greece.
Okay, and Mr. Rogers and Mr. T, do you have your witnesses here?
Your Honor, we don't have any additional witnesses other than those called by the Commonwealth.
Same.
Oh, all right, thank you very much.
Same blood.
Okay. Now, I have a few questions.
Totally off the wall, but Maria, I'm close to being monetized, so I'm going to have those cute little emojis. Y'all know that one stupid thing I've been striving for is to have membership so I can have damn emojis. I'm fucking addicted to emojis, guys. I want emojis. So I'm just a couple hundred hours off. So, this has been a slow road. I have not, I've totally enjoyed the time we've all had together. It's beautiful how this has grown organically. I wasn't promoted by anyone. I wasn't out here asking anybody to push me, get me there. And here we are. And I want you all to know I appreciate every one of you. So anyways, sorry. One of those blubbery moments.
That are going to instruct on what the law is and to assess your ability to follow that. Do each of you understand that the defendant is presumed by law to be innocent of the offenses for which she is charged, and that the presumption of innocence remains with the defendant throughout the trial?
Okay, this is a criminal trial, so we have to say yes. She's presumed innocent. We're not going to judge her on the fact we're not, I'm going to turn my camera on to say that we are not going to judge her on the fact that she already has a $10 million judgment against her in a civil suit for the same matter. So we're gonna completely block all that knowledge out, and we're gonna go with a fresh mind in this trial, and we're just gonna learn as we go. Right? Everybody say yes. That's what the jury says, right? The jury said yes.
And that the presumption of innocence remains with the defendant throughout the trial.
Yes.
Are you able to follow that rule of law? Yes. Is there anyone who
Yes.
is not able to follow that rule of law?
No.
Do you understand that the law requires that the Commonwealth prove the defendant's guilt beyond a reasonable doubt?
Yes.
Are you able to follow that rule of law?
Yes.
Is there anyone who is not able to follow that rule of law?
No.
Do you understand that during the trial, the defendant is not required to testify or to produce any evidence?
Yes.
Are you able to follow that rule of law?
Yes.
Is there anyone not able to follow that rule of law?
No.
And like I said earlier, there are no right or wrong answers, we just want the truth. Do you understand that the defendant's election to not testify cannot be considered by the jury in arriving at a verdict?
Yes.
Are you able to follow that rule of law?
Yes. Gonna try.
Anyone who is not able to follow that rule of law?
Think of planets as neat spheres orbiting the sun.
Do you know of any reason whatsoever why you were unable to give a fair and impartial trial to the Commonwealth of Virginia and to the defendant Ebony Parker, based solely on the law and evidence? Okay, I have two numbers, 22 and, hold on, 68. Is that 68? And 80. Okay, we'll start with 22. Yes.
I've been following social media of the case.
Okay, don't tell me what you saw on it, but that's influenced you.
I believe the media has confirmed and wants to do the live.
Okay, hold on, okay.
Its atmosphere is thick.
And we're gonna get to the media questions too, but thank you. I'm gonna go on it first order and then I'm gonna come back around. So what is this?
I've been trying. Yeah, Maria, we had a lost wallet. We had a lot. No. There's Hectorius is home today. See, what happened was when a man loses his wallet, the whole fucking world stops. Okay, for over 2.5 hours, we wallet searched so much that we had to call in sick to work. And God, I hope none of his coworkers watches my stream. But yeah, so yeah, we have Hectorius in the background watching movies. So, but he's been good. He's gotten me my coffee and everything.
Clockwise. Okay, so juror number 68. Yes. What's your concern?
I have personal feelings for this that I think would influence my answer towards them.
Okay, and don't tell me what those are.
Personal issues that would influence my answer. Okay.
But we may follow up privately. Thank you for letting me know.
Judge, what number was the most recent?
68. Sir, you were 68. I want to confirm.
Yes, ma'am.
Thank you.
Thank you.
Entire civilization. Your ancestors recorded these as divine punishment.
And I believe at juror number 80. Okay, yes, ma'am.
I personally feel like I'm too biased to be on the stand for this case. I work at the hospital, so I see situations like this all the time.
Oh.
I think it's the first time I ever had.
Thank you.
Ooh, damn, girl.
Oh, okay. Now I saw there was some other.
Yes,
people who,
absolutely, Cindy.
Did answer with their number that they had.
You know, Cindy, here. Between you, me, and the chat, and the whole fucking world. He actually got to use sick time, so I was worried about him losing a day of pay because he lost his wallet. And then I kept thinking about everything we had to replace in that damn wallet. All the credit cards, his driver's license, social security, all that. I was like, oh my God. And to think I dug in the damn trash to find the stupid thing. Oh, I love that man.
Concerns if they can give a fair and impartial trial. And so I'm going to start back around. In the, those in the jury box, number 6. Okay. And what are your concerns, or what's the basis for your concerns without giving me too much information?
Well, I have personal concerns about it because it's something happens to my son. years ago, dealing with something like that.
Okay, thank you.
Yes, case one. In the damn trash can. I dug it out. He dropped it in the trash. Kitchen trash. Kitchen. Banana peels and half-eaten hamburgers.
Worship is not symbolic. It is energetic. The emotions of fear, awe, devotion.
Okay, and then to the section to my right, juror number 16, yes, please.
Just to tell you, he did that because when he was over there at the kitchen sink and my trash can was real close to the kitchen sink and he knocked something off the counter, which was a glass, and it fell into the trash can. And when it did, he had his wallet at the same time he had that glass when he was getting it picked back up, and somehow he lost, it fell into the trash can. And that was the last place I ever thought to look because we tore this house apart for 2 hours. He was supposed to leave at 3:30 and it was 5:30 before we found it. So that's why I was late getting to stream today. Yeah.
My mother is a retired school principal, and most of my friends are teachers somewhere. And also, I am a big proponent for the Second Amendment.
All right, thank you.
Not only for territory, but the emotional resonance generated on the battlefield.
All right, in this section, and that's 58, yes, please.
Some view humanity as conflicted for item, others as battle.
Oh, thank you.
This conflict among them has been humanity's fragile shield. It is why you were not.
All right, moving to the third section, juror number 79,
Why
yes.
you still dream of freedom.
Very biased.
They are.
I'm very biased.
Sorry, Abigail.
Okay, all right, thank you.
Did you fucking hear? Did y'all hear that? I'm sorry. We're going to rewind because I need to make sure y'all heard what I heard. I don't know what to think. I don't know what to Ooh, now my nosy self really wants to know. Okay, y'all listen. Ready? I'm going to hit play again.
All right, moving to the third section, juror number 79, yes.
Very biased. Towards Miss, sorry, Abigail.
Okay, all right, thank you.
She is biased to Abigail. So she's already got her mind made up. She's like, you're picking the wrong bitch. I totally think she totally deserves everything. So she got the axe. Right? What is the Second Amendment? I don't know. Cindy beats me. In the Second Amendment, freedom of speech? Fuck, I might be wrong. Because that's too many years ago. Yeah, she wanted out, case one. She needed an excuse to get out. Second Amendment to bear arms. Okay, Second Amendment is to bear arms. First Amendment is freedom of speech. Second Amendment is to bear arms. So to bear arms. So that's interesting. Yeah, she wanted out. We can say weapons in here. I hate the word pew pew. This sounds so. They're weapons. They're firearms. You don't have to say gun, but you could say weapons and you could say firearms. Pew pew sounds like you're talking to a 2-year-old. Don't touch the pew pew. Okay, I'm sorry. I'm not trying to tease y'all. I'm not trying to make fun of y'all. It's just one of those things like going to the chats and they're like, and he had a stabby pokey thingy. I'm like, it was a weapon. We're just gonna call it a weapon. We're gonna sum it up as a weapon.
It's a weapon. Okay. You don't have to say knife. I mean, although I do, but it's a weapon. Okay. I'm going to shut up.
Anyone else in that section? Okay, juror number 69? Yes.
Just saw things on social media that was maybe biased.
Okay. So
6'9" is like,
Tell me what, some people-
okay, I can tell you right now, 6'9" don't want to be there. Number 69 wants out. She wants way out because she's every time she's asking a question, she's got a reason. Okay, what was her reason this time?
Okay, juror number 69? Yes.
I just saw things on social media that was maybe biased.
All
Okay,
things
something you-
social
yeah,
media.
You cannot tell me what, but something you saw in the media has persuaded you. Okay, thank you.
Hannah and a binky.
Okay, any other numbers to that question? Okay, I'm circling back to juror number 13. Yes, please.
I'm familiar through social media with the trial. My husband and many family members are also teachers.
Yeah, Cindy, I'm with you.
I was engineered for
All right, thank you.
see beyond the physical spectrum into ultraviolet.
So how are they going to pick 12 jurors out of this? I will let y'all know they did pick 12 and opening statements are tomorrow. So that's something to look forward. So I know tomorrow we will have opening statements. I'm excited.
Anyone else? And my last question. Do any of you have any religious or other moral reservations about passing judgment on another person? Okay, juror number 22. Yes, please stand up for me and tell me what those are.
I don't believe I should judge any person because I will never have all the information available. I believe it's self-esteem.
Okay, thank you.
Experiments continue.
She can't judge another person because she'll never have all the information available. Okay.
Some are children of volunteers.
Oh, you think so, Cindy? Girl, she don't even need glasses, right?
We've been going about 40 minutes, so we'll go a little bit more before we take a break. Does the Commonwealth have any relevant questions on what you?
We do.
Reiterate what the judge said earlier. Thank you for doing this. I know it is an inconvenience and we all appreciate your service. I have a few questions. With this first question, I'm just going to ask you to raise your number if it's a yes. Have any of you served as a juror before in any trials? Just hold up your number if you have. I'm going to start here and I'll work my way up around the room. Who was in this box? Number 6, are you holding yours up? I can't.
No.
Okay, thank you. Number 11, you have served as a juror on another case?
40 years.
Okay, was it, if you remember, was it a criminal case or a civil case?
It was criminal.
Okay, and if you remember, did your jury reach a verdict of some kind? Okay, and do you believe that the outcome was fair under the circumstances of that process? Okay, thank you. Anyone else in the box served on a jury? Okay, we'll go to this side now. I see number 18. I'll start with you, sir. You have served on a jury? Okay, if you remember, was it a criminal or a civil case? Okay, and did your jury reach a verdict of some kind? It doesn't matter to me what the verdict was. Did they reach a verdict?
Yes.
Okay, and do you believe overall that the verdict your jury reached was fair, whatever it was? Okay, thank you, sir. Who else in number 15? You have served as a juror before, ma'am?
Yeah.
And was it a criminal case or a civil case? Criminal, is that right?
Yeah.
And did it reach a verdict?
I wasn't there long enough to
Understand. Anything about that process that you thought was unfair for the part you were involved in? Okay, thank you. Standing back, yes, number 25, you served on a jury, was it criminal or civil? It was criminal. And did that jury reach a verdict? It doesn't matter what it was. Okay, and whatever it was, do you believe the outcome was fair under the circumstances of that case?
Yes, I do.
Okay, thank you. Anyone else right here? Taking back. The next one I
Will
see is
criminal
4,
appeals
served on a juryman.
Yeah, criminal, which means reduce endless food.
Okay, and anything about going through that process and the mistrial that you thought was unfair? Okay.
It will dangle.
Looking for number 60 is the next one. I see you served on the jury. And a civil case, and did the civil jury reach a verdict? And do you think the process and the outcome was fair? Okay, thank you.
Immortality.
Number 65, same questions to you, sir. A grand jury. Okay.
Grand jury.
That you
Ooh.
served on, did it have anything to do with the case for which we've all been brought here today? No? And how long ago was that?
Each cycle of
Okay.
6 or 7 years
Anything about the
ago.
process of serving on a grand jury that you thought was unfair? All right, thank you. Anyone else on this side that I missed? All right, thanks. Over here, number 71, you served as a juror.
Yes.
Was it criminal or civil?
Criminal.
And did the jury reach a verdict?
Yes.
Do you think the outcome was fair under the circumstances?
Yes.
All right. Number 70, you served.
Yes.
And was it criminal or civil?
Civil.
And did it reach a verdict?
Yes.
Did you think that the outcome was fair?
Case one, are you
Number
serious?
78, same questions.
Yes, and criminal, but they reached a plea deal before jury deliberation.
Okay. Anything about the process as it unfolded that you thought was unfair? No. Okay. Anyone else? Anyone I missed? Okay, thank you.
Right.
The second question, if you need to answer the question privately, we will just write down your number and do that. If you're okay speaking about it, I'm going to ask only very limited follow-up questions about this. But the question is, have you or any member of your immediate family ever been accused of a crime? So immediate family means people that you live with or have lived with. And a crime does not include traffic matters like speeding or parking tickets or anything like that. So have you or any member of your family ever been accused of a crime? And then I'm going to preview, if you answer yes, I'm going to preview what the next couple of questions will be so you can decide whether you can answer publicly or not. I will ask you how long ago, in what city or state. I'll ask you whether a case went to court. And then I'll say, whatever the outcome was of the case, do you believe it was fair under the circumstances? And that's it. So I won't be asking you about the details of the accusation. Okay? So to the question, have you or any member of your immediate family ever been accused of a crime? I'll start here. Hold up your numbers, please. Number 9.
No.
If you're comfortable answering, how long ago was that?
Believe humanity may one day
Was it you or a family member?
Oh, wait. You or a okay. If it was a family member, yeah, family member. Sorry, I
And
misunderstood.
what city or state? Did it
Houston,
go to
Texas.
court? And whatever the outcome was, it doesn't matter to me, but do you believe it was a fair outcome or not?
Yes.
Okay.
Honestly, no. She should have got more, but
Number 11, you or an immediate family member? Understood. And how long ago was that? And in what city? Okay. And did it go to court, if you know? Okay. And do you believe the outcome was fair under the circumstances? No. Okay. Anyone else? All right. So on this side, number 16. Was it you or an immediate family member?
Immediate family member?
How long ago?
I'm not sure the exact timeline. I'm in the.
I'm gonna tell y'all something just because I like y'all. I usually wait until after I stream or do my regular things to do the dishes. Hector's in the kitchen doing the dishes. I'm so shocked. It's not his thing. He never does. It's just something I've always done. But because he's home, I guess he's bored. He's doing the dishes. Your ex-husband's in prison for life and stuff. Yeah, my ex-husband's done a couple rounds. So he's he's been in there a couple times. I know, Maria. I'm so excited. I'm so excited. That's why I'm whispering, because I don't want him to know I was watching him. I don't want him to know I was watching him. but I was peeping around my monitor, and he's in there watching.
Process of a divorce, and I found out after the date of the marriage that my husband had assaulted other women before me, and also been arrested for assaulting.
Oh, snap!
Okay, thank you. Number 17, just so that you are an immediate family member, I know the answer. If you don't mind standing up, though, let me go ahead and ask you the questions for the record.
Well, there's
Okay?
another one too, so I'll
Okay. Okay, so you were an immediate family member.
Strong, still flesh.
And how long ago?
When they return home, choose the form that suits them.
There's
You can give me a couple, the most recent.
Alien.
It's just not his job. That's my housewife duty. You
And
know?
did it go to court? And do you think the outcome was fair under the circumstances? Okay. Number 19, you were an immediate family member. Okay, and how long ago? 20 years. 20 years.
20 years.
And did that actually go to court? And whatever the outcome was, did you think it was a fair outcome? Okay, thank you. Looking back, number 28, was it you or an immediate family member, number 28?
Immediate family member.
Okay, if you can stand, that would be helpful for us all to hear you. And how long ago, roughly?
2 to 3 years ago.
Okay, what city and state is that?
Y'all, I know I'm so side-railed by this. I know, but y'all have to understand, I am the caregiver person. I'm the one that takes care of everybody. I take care of everything, like washing the clothes, washing the dishes. I don't have a dishwasher. I wash them by hand. You know, I do all the cooking. I take care of mom. I take care of my son, you know. So for somebody to take initiative and actually get up and do something that I feel is supposed to be my job, you know, it's like I'm just, I don't know. It grabs my heart, and y'all know how I feel about him. So I know that's a total stupid squirrel side rail, but you know, thank you. Maria. Yeah, and I think he is feeling guilty for not going to work. He's like, let me go over there. Look.
Thank you. Did it go to court?
Oh, the court order needs her. She didn't hear you. Say it again, please.
Eastville, Virginia.
It's hard, Maria. I'm a caretaker, not a gift. I don't.
And whatever the outcome it was,
I take care of
under the
everyone.
circumstances.
Anyways.
All right, thank you. And is that 29? You were an immediate family member.
Immediate.
All right, how long ago?
20 years.
20 years, all right. In what city or state?
Garrett.
I couldn't hear that city.
Garrett.
Jared?
Garrett.
Yes.
J-A-R-R-A-T-T. Garrett,
Thank
Virginia.
you. Did that go to court? And whatever the outcome was, do you think it was a fair outcome? Yes. Okay, thank you. Number 30?
Yes. It was an immediate family member.
Okay, and how long ago?
Within the last year.
Okay, in what city or state?
Newport News.
Okay, we're gonna bump him a minute.
79, 78, 70, 69, 81, 83, and then I saw juror number 84 had a question. So number 84, you have a question about that?
I have met.
No, we can talk about it privately. So I'm just going to put a note that we can talk about it privately. 84 wishes to speak about something privately. Okay, so similar question. Has anyone here had discussions, either commenting online or discussions offline, person to person, specifically about Dr. Ebony Parker? By show of number.
Hybrids are an insurance.
Okay, again, what I'm going to do
Look,
is
80s cards up, y'all. I see 80s. I bet you 79's doing it too.
Number 13, number 15.
Oh, we got you, Maria.
25.
Oh, we have a visitor.
36,
Y'all. Okay.
41.
Wait, y'all. We have to pause and go big screen. We have to pause and look. Hi. Say hi. No, you can't have no coffee. You can't have no coffee. Say hi. It's a Lola time. Hi, Daddy. Oh, yeah, Daddy take care of you? Yeah, her come say hi. Lola, say hi. Okay, okay. So we got our Lola moment. You know, she had to come say hi.
43, 45, 47, 48, 49.
And Ms. Jenkins, you're going a little bit too fast for me. I last marked at 43.
Can everyone raise your hand up?
Okay, no, I got, okay.
That's 43.
Okay, 45, thank you, okay.
45, 47, 48, 49, 58, 59, 64, 65,
You should see pictures of Tolly, Maria.
61,
Tolly's gotten big.
69, 70, 78, 79, 80, 81, 82, and 83, and 84 wants to speak privately about this matter. Understood. All right.
Go check Daddy.
Question just by showing your number. Did anyone here watch on television or the internet any part of the actual civil trial related to this incident in Rich Neck Elementary School? Watch any part of the trial itself, okay? We'll list the numbers 6.
Here we go.
13.
Okay, so if these people have seen the civil trial, they're cut. Yeah, we've seen the civil trial, so we'd be cut. But we'll pretend. Let's pretend we haven't seen it, and we're going to be totally open to the idea of what happened and Miss Ebony's innocence.
15, 16, 22, 23, 30, 34, 41, 45, 47, 58, 59.
Look at him, look at his lips. He's like, fuck, I'm losing a whole bunch of jurors right here. Ooh, look at that. Oh, good freeze too, right? Good freeze. He's like, oh, fuck. I ain't got many more of these people left. I'm losing them left and right.
9, 61, 62, 64.
Hannah's
65,
judgmental. She'll always be
76,
judgmental.
79, 80,
80.
81,
Told you.
and 83.
Told you,
More
80
minutes.
was out. Cindy's got her fingers crossed. No, we didn't know anything about civil trial. Nope.
Is there anyone here, based on that pre-existing knowledge, who has already formed an opinion about the guilt or innocence of Dr. Parker?
Nope.
Raise the numbers. I'm starting with the jury box. Any
That's a
numbers?
lie.
All right, number 13, I'm not going to ask you what your opinion is about the guilt or innocence of Dr. Parker, but what I am going to ask is whether if the court were to instruct you to be fair and follow the law, would you be capable of setting up an opinion aside?
Cindy
and just making a
and
decision
Maria are on the
based
same
evidence
thought.
you see? Is that yes? And your number again? 13, thank you. Any others?
Yeah, they would have to pull a whole nother jury. They'd have to pull a whole nother jury of people in and go through all this voir dire with them to find more. If this 80, well, I thought it was 80, but it might have been 100 of people that they had already had come up there. So, I mean, they'd have to carry on, you know. But I can tell you, they do have a jury pulled. There is a jury. They do have 12 people, and we will have opening statements tomorrow. So
in the box. Okay. So number 15, would you be able to set aside a preconceived idea and still give a fair hearing to both sides in this case? Okay, thank you. Number 16, same question. Would you be able to set aside a preconceived idea and give a fair hearing to both sides in this case.
I've been studying law at Regent University, and I want to hear the details.
Okay, me too. I studied there as well. 22, you don't know, all right. 23, would you be able to set aside an opinion and give a fair trial?
Yeah, because they have to have.
Okay, I see.
They have
you're
to
not-
have
She said
two
yes,
alternatives.
23 said yes.
Yeah.
Okay, and thank you. And, I know it's custom to nod our heads, but Madam Court Reporter has to record audible, verbal responses. Thank you.
I'm sorry, Your Honor. So, I believe 22 responded, is that
Yes.
correct? And I guess there was, I didn't hear the response.
That's what I don't know, honestly.
Don't know, okay.
Okay. Anyone else on this? 25, would you be able to set aside an opinion and still give a fair hearing to both sides?
I'm not sure.
All right, number 30, same question.
Yes.
Yes, you would? All right. Number 34, would you be able to set aside an opinion?
I'm not sure.
Okay. Number 36, could you give a fair hearing to both sides?
Yep.
Okay. Number 41, would you be able to give a fair hearing to both sides? Okay, unsure. I haven't heard from that one. 41. Number 45, would you be able to set aside your opinion and give a fair hearing?
Yeah, they have 14. They have 14. There's 12 jurors and 2 alternatives. Yeah, I just went and looked that up. So they go to lunch. So let's fast forward until they come back and they're going to ask some more questions. Let's see, what's this? This may just be some pre stuff before.
All right, and I'm gonna take attendance. So, we'll start with the gentleman in the first row, to the wall, mine far right. And if you just read your number, so I wanna make sure we have the right numbers in the courtroom, the right juror numbers.
11.
Thank you.
17.
So see, they've picked some out now. So now they've come back and they've kind of chopped them down now. So now we got 11, 17. So Cindy, does that mean you're still in there?
22, 45, 58, 59,
68.
46.
47, 49,
71.
80, 79.
80's still there and 79?
Thank you. And we are able to excuse you from this jury. Thank you for coming down today, and I appreciate your answers.
They're the ones that are gone.
And so,
Bye-bye.
instructions for
Bye.
service during this term. You will need to call back next Tuesday, May 26th after 5 to see if you need to report for any other juries. You are excused from juries this week. And the sheriff will indicate how they're going to.
I think 16 got it. Look, let's go through the numbers again just for fun because that was hilarious. That was hilarious.
Okay, all right. And Sheriff, you'll escort her out of the building. Thank you very much. Thank you all for your service.
Oh, wait, there was another round before that? Hold up. Hold up. We might have missed another little part. Hold up. These are the leaving ones.
I think that the audio was still recording during the break. So to the news, media, I think that was the microphone at the podium still recording during the break, audio?
Usually I put this into what we call Marlin tone.
Okay.
Which cancels everything out and just sends it back, but probably be looking.
Oh, she thought they were recording sound
Okay, but they can't
while the
hear
break.
anything over that screen.
Correct.
Okay, understood, thank you. Okay. All right, but everything. Yes.
On that point, I believe that they could hear something.
Somebody was reporting to me that they could hear it. It was a hot mic.
Uh-oh, they had a hot mic.
Audio from your microphone transmitted somewhere because unless they're taking a feed elsewhere, it wouldn't go into any other place.
Okay, so I'm just, I guess, caution all parties in the courtroom, I don't know what, but they could hear, I think some of the bailiffs just procedurally moving around. The hot mic is here, but okay, yes, Mr. James, you want to take something else?
Just quickly, Judge, if you would like to take it up, defense counsel and I conferred, and we have a list of jurors that we already agree should be released for cause. And I think we agree that these could be released even before the defense continues their voir dire, if you would like to do that.
Okay, I have no objection to that, and that way we can release people. And then somebody said number 15 is not feeling well.
That is one of the ones.
Okay. Okay, so we'll release her first. Do we need to get medical attention for the juror?
She said it was just difficult for her to breathe while in there, so, let's find out.
Okay, just bring number 15, if she's having breathing problems.
Okay.
And good afternoon, ma'am. I just want to confirm you are juror number 15?
Okay.
Okay. It's my understanding you are having some breathing.
Oh, here's 15. So 15 they let go.
And I just want to say, we appreciate you coming down.
Okay, so 15's gone.
Did you inform the jury coordinator?
No, not about the past hours.
Okay, please let the jury coordinator know.
They scar it. Poison it.
Okay, all right. And Chair, you'll escort her out of the building. Thank you very much.
Thank you all for your service.
Okay, so we got that one gone. That was 15.
The numbers that we have agreed to, Judge, and I know defense counsel is double checking me if I get one wrong, speak up. Number 11 indicated a religious holiday.
When the cycle turns again.
Okay.
Number 15's already been excused. Number 17 knows me from a prior case.
Okay, no objection to that. Okay, these are all agreed upon. Okay, yes, go ahead.
You remember your bond.
Number 47.
So I didn't say 16 yet.
Caretaker for the father.
You are hybrids of
Number 49.
If you honor Earth.
Don't remember exactly why.
He's a former paralegal for
Thank you.
Hampton County Attorney's Office.
Paralegal for Hampton County Attorney's Office. Number 71 had indicated knowledge of Molly Newton. Number 79 indicated being friends with Ms. Zwerner.
We knew she was going.
3 knows another prosecutor in my office. And Judge, we've also agreed on the following people because they were adamant they could not be there. And so those numbers are 45, 46, 47, 58, 59, 68, 79, 80, and 81. I think that's all.
And 83.
And 80.
Okay, let me go back over that to make sure I.
We could have.
You remember your inheritance. Not from God.
I'm gonna ask you some questions, and so please.
You see the masses
Okay.
for what they are.
So now they're going to do, so now this is the last part of it. And it's not that long because they actually leave. So it's probably, it may be about 40 minutes. So, okay. This is the defense doing the voir dire for Miss Ebony side. Him asking the questions.
Right here. Should be 6 on it. Yeah.
My prophecy is not.
Hi, Miss Ebony. How you doing?
You may be seated.
Look, Cindy got them numbers.
Return by number or just do a head count? I believe we in the jury box. And Chair, we have even rows of 6 until we get to the last row. Is that correct?
That's 6 also.
Oh, that's 6 also. Okay.
Humanity's story has always been one.
Which means I should have 8 rows of 6.
It's
9.
Okay, I'm gonna let this play. I'm gonna go refill my coffee again. I'm not gonna ask him to just because I can't do that. And I'm gonna take a potty break, but I'm gonna listen on my phone, and because y'all can walk around and do that, and I can't do that. So I'm gonna go do that, but I'm listening. But y'all see an empty chair. But I'll be right back.
Okay.
9-6.
All right.
And I smell Hector cooking waffles. This man, when he stays home.
54 plus 14 is 68. And we started with 84. We excuse.
He's cooking waffles.
So we have the correct number. Good. We have 68. Okay. And thank you all for returning. I hope you had an adequate chance to refresh yourselves. There was a cautionary instruction not to discuss the case, not to research the case, not to investigate, and if anyone approaches you, to tell them they cannot talk about the case. Does anybody wish to report an issue with those instructions?
Right, Cindy?
No issues being reported. We will turn it over to the defense. Mr. Rogers, Mr. T, do you all wish to pose any voir dire questions to the jury?
Yes, Your Honor.
Okay, you may proceed.
Thank you. Good afternoon, everyone. I'm Stephen Teague. I am co-counsel with Curtis Rogers on behalf of the defendant, Dr. Ebony Parker. I'm going to ask you some questions, and so please just raise your numbers if it applies to you. Are there any people here that are retired? So nobody in the jury box is retired? Okay. So we have 29, 38, 18, 44. When I call your name, you can just put your name, your number down. 48, 63, 64, 19. Anyone else retired? 18, yes, I have it. Thank you, sir. All right, for those who are retired, what job did you retire from? So let's start with 18.
I'm working for the state of Delaware.
State of Delaware. All right, 19.
After my 62.
I'm sorry?
I started on Social Security after my 62.
Okay. What job did you retire from?
So, I was working in different places, but I was a service-connected disabled veteran.
Okay.
Yeah.
Okay, thank you. All right, 29.
I retired from the military in Air Force and I'm responsible for tracking civil service.
Thank you. 38. Xerox technician. Thank you.
In the high desert of northern New Mexico,
We next have 44.
are said to still wonder and
What?
rising
Thank you, ma'am. Auto injury claims adjuster.
so disturbing that those who dared
What?
to
48. Thank you, sir.
What?
63. Surgical technologist. Thank you, ma'am. 64. Designer and engineering department in Newport News Shipyard. Did I miss anyone? Okay, thank you.
You hear me?
Besides juror number 29, did anyone else serve in the military? Let's start with the jury box. Number 2, thank you. Okay, let's go in order. 25, 23, 30.
Up front, I guess.
Once 19. Once I call your number, you put your number down. 36, thank you. 37, 51, 56, 57, and 7.
Okay, hold on. Sorry. Okay, 51, and after 51 was number 56,
56.
and then 57.
Oh, that was hilarious.
And
I'm sorry.
7.
He's trying to feed Lola the waffles.
Is anyone here related to anyone in law enforcement? So let's start with the jury box. No one there? All right. Let's start with, if you could just put your numbers up, okay? Put your numbers up, hold them up, please.
I'm fucking dead. I'm fucking dead. I'm fucking dead. I'm sorry. What? She's playing with the waffle? I told y'all. See, this is why I don't stream with anybody. So y'all just don't know. My house is just my house. They heard everything. Hey, what? Turn TV now. They're over here. Hot mic, hot mic. He's cracking up. Yep. See? I have a normal house. Everybody knows now. My house is normal. Okay, 16 is gone. Whew, okay.
Let's start with number 34. It's okay. You can, if it's someone in your immediate family, please let us know that. But other than that, just tell us yes or no.
My cousin is.
Okay, 34. Thank you. Oh, I'm sorry.
In a different state.
In a different state. Thank you. 38.
Cousin, yeah.
Okay. 54.
My son, Blacksburg.
Thank you. 62.
My cousin here.
All right. And 63.
My ex-husband, 25 years in you.
Thank you. And 76.
Cousin here.
Thank you. Does anyone have friends in law enforcement?
No.
All right, let's start with jury box.
I'm gonna lie. I'm gonna say no, but really, to be honest, Mom's brother is a police chief. Shh. Don't tell nobody. Mom's brother's a police chief. See, Mastiff is over there playing with the duck butt and the meat. You said yes to family. Yeah, I'd have to say yes too because, he is the sheriff. So I guess that's a yes.
16. Thank you.
But I shouldn't be dismissed for that.
3.
It's a whole nother town. You'll heal. You'll heal.
Thank you.
Thank you for being there.
9.
I'm not sure, but
And you know that you can block the wild. I've seen that there was some wild thing earlier that somebody was typing in there, and you know how to block, I think. So.
I have an uncle that is a lawyer in Illinois.
Okay, thank you. 1.
Friend, Hampton Roads Police.
Okay, thank you. 24. Newport News. 30.
Several in Newport News Police Department. And some in the Sheriff's Department.
All right, thank you.
Got tons of family.
34.
Mine were all union workers. They didn't do
Here.
like police or anything. They did like because we have all the plants down here,
41.
all the chemical plants and stuff like that. Monsanto, BP, all that.
62. All right, thank you. 65. Thank you. 75, 74, I'm sorry.
Does it count if they're a judge? I know them by association.
Does it count if it's a judge? I know them by association. Okay. I would say, yeah, that's close to law enforcement, but that's not law enforcement. And what kind of trouble would she have gotten into had she not revealed that? And further down the line, these people be like, oh, technicality.
Here.
Okay, Newport News, okay.
She'll be next.
And Circuit Court of GDC.
Circuit Court.
All right, 75.
Magistrate judge in
Thank you.
Judge is a father figure in North Carolina.
Oh, sorry, 50? 50?
Hey,
Newport News?
y'all stop.
Circuit Court or General District Court? 70?
I love that duck butt.
Okay, thank you.
I can't get over that damn duck butt.
Anyone else that I missed?
Stop the crying.
73?
Stop it.
Both retired judges from Newport News. I went to school with their kids.
Okay, thank you.
She's gonna go.
Does anyone have any friends or family members in the Commonwealth's Attorney's Office? That's the prosecutor's office in Virginia. Any prosecutors' offices in the cities in Virginia, period.
I think my professor was a prosecutor in Chesapeake.
Okay, your juror number
16.
16, thank you. Anyone else?
Oh, that's cool, Cindy. I wanted to be a Texas history teacher. I wanted to teach Texas history.
Does anyone here work in the field of education? Okay.
When I was
8.
little. And then I wanted to be a caregiver.
What, are you in Newport News?
Yes, teacher.
Thank you. Number 20.
Teacher in Newport News.
You know, Newport News is a weird name for a school district. The Newport News School District. Where do you work? At the Newport News School District. Kind of weird. I don't know. When you say news, I think of news.
51.
Teacher suck.
78.
I'm former Newport News teacher.
Can you repeat that last?
Sure, now I live at Winsburg.
Okay, thank you. It's 84.
I'm a behavioral therapist, but we sometimes do in-school therapy as well.
Okay, thank you. 70.
Okay, and sorry, if you could stay in, please. Madam Court Reporter wasn't able to hear your response. Give me your number again.
7.
Thank you.
Product trainer at Newport Leadership Building, the front.
Okay, thank you.
Newport Richie. God, Cindy, that city name just triggers me.
Anyone that works in the field of education. All right, 16. 13. 10. 9. 1. 20. 33. 34. 32. 38. 42. 61. 57. 65. 69. 74. 75. And 76. Thank you. And of those who just raised their numbers, how many of those family members work in Newport News?
Not public.
Okay.
Newport News private.
Okay.
Stop, K-SWAT.
10, 13, 69, and 76. 61, 42, 38, 32, 74.
I'm also not sure.
Okay, thank you. Now, does anyone have friends that work in the field of education? All right, 16, 10, 13, 12, 5, 7, 20, 33, 34, 36, 41, 51, 52, 57, 67, 69, 70, 75, 76, 78. And of those who just raised their numbers, do your friends work in Newport News? If they do, raise your number. 6,
Pull tabs.
12, 13, 10, 5, 34, 36, 57, 70, 67, 69, 76, 78. Thank you. Do you know anyone that works for Newport News Public Schools? 16, 14, 13, 10, 5, 3, 19, 20, 23, 30, 34, 32, 36, 41, 42, 50, 55, 61, 62, 63, 57, 64, 69, 70, 67, 65, 73, 75, 76, 77, 78. Thank you. Has anyone here been the victim of a crime? Okay, juror number 9, juror number 2, 34.
I'm so confused at numbers. Look, this man can keep on reading numbers, but guess what? It's the end of the day, and y'all got me over here.
Sheriff kicked down my door. Then I heard the glass spray. They found no kidnapping victims, just some lemon pound cake. Mama's lemon pound cake.
All right, everybody with me.
It tastes so nice. It made the sheriff wanna put down his gun and cut him a slice. He's a Adams County sheriff. He's hungry and he's big as hell. He was sniffing for weed. Then he smelled another
smell.
What was that? Mama's lemon pound cake. It tastes.
Look, I yeeted myself from the damn stage. Wait, I have one more thing I'm going to show y'all real quick. And then we're going to head out. So we're going to sum it up with this one. This one's going to sum it up. Y'all, we had a bingo. You have a bingo. Everybody's got a bingo. C Mastiff is doing the duck butt for me over there on my kick. Thank you for that. Y'all, it's been crazy. And I'm so glad y'all spent this last 4 hours with me, whether you were here the whole time or in and out. So this is just going to kind of give you a little rundown of the trial real quick before we go.
Classroom shooting at Richneck.
It's 6 minutes long. So, and then we'll do the little say goodbye.
Elementary in Newport News, an historic trial is about to start. Tomorrow, former assistant principal Ebony Parker will face a jury over her actions that day. Parker is accused of ignoring warning signs before a 6-year-old shot his teacher. 13 News Now is looking at how we got from that day all the way here to the start of this trial. Our coverage starts with Patrick Gray, who joins us here in studio and takes us back to the day of the shooting. Patrick.
Madison, police say on the morning of January 6, 2023, a 6-year-old student arrived at Rich Neck Elementary School in Newport News with a loaded handgun in his backpack. By late morning, warning signs started emerging. Abby Zwerner's attorney, Diane Toscano, said that Zwerner had noticed the student was off and was in a violent mood, threatening another student earlier that.
So right here, we had the news telling us this. The student was off. You know, that's why we wanted to put all those little pieces together so y'all could see. Now, here we are, and tomorrow we're going to have opening statements. I'm so freaking excited.
That day. Soon after, a reading specialist, Amy Kovac, reported that students said the boy had a gun in his backpack. Kovac.
That's the first time I've seen it, and we're going to let that fly by because I hear channels have been getting hit for showing weapons like that. So, but we've seen how big that was, and if you didn't see, you are more than welcome to hit rewind because I don't play that. You can't rewind my shit. I don't delete nothing. So it's there. Rewind on your own. We had talked about the size, how big, if a 6-year-old could conceal that. Whoa. Okay. We're going to let him finish talking. That took me. Whew.
Alerted Vice Principal Ebony Parker and even searched the backpack herself. She found nothing, but texts unveiled in court show Zwerner believed the student had already removed something.
Says, Amy, I can't stop thinking about you. Yes, Kovac, you're truly an amazing, brave, and compassionate person. You're an amazing person and educator. No one could have ever predicted this. We all did our best. We did what a true teacher will do in this situation. Be there for our children and school. As I look back, I should have sent JT out of the room with a note and a job to deliver it around the school, and I could have gotten that book bag, but I didn't. We can't look back, but we can only move forward. I love you both, and I'm proud to work with you both.
From the bag before recess, and Kovac warned the gun could be in the child's pocket. Attorneys say at no point did Parker call police, search the student, or even leave her office, despite 3 warnings from teachers. Meanwhile, other students later said the boy showed them the gun at recess and threatened to shoot if they told anyone. And just before 2 p.m., back in the classroom, the student stood up and fired 1 shot. The bullet went through Zwerner's hand and into her chest.
Obvious, I thought I was dying. I thought I had died. I thought I was either on my way to heaven or in heaven.
She suffered life-threatening injuries and was taken to the hospital where she spent weeks recovering. What started as warning signs that morning ended in a shooting that would spark national attention and several legal battles. The student's mother was convicted of child neglect in state court and lying on a gun application at the federal level in 2023. A jury found Parker liable in a civil case in 2025. Now, Parker is set to go on trial tomorrow, accused of child neglect for her alleged lack of action after warnings. Patrick Gray, 13 News Now.
All right, thank you so much, Patrick. And from there, on January 25th of 2023, massive leadership changes hit Newport News schools following the Rich Neck Elementary shooting. Assistant Principal Dr. Ebony Parker officially resigned. Meanwhile, the school board voted 5-1 to fire Superintendent Dr. George Parker, appointing Michelle Mitchell to serve as interim superintendent. 4 days later, on January 29th, Newport News Public Schools confirmed Rich Neck Principal Brianna Foster Newton was reassigned within the district. And over the coming months, the students would return to the classrooms. The shooting investigation would be completed, and Abby Zwerner would issue her first statement and get ready to file a lawsuit. On April 3rd of 2023, Zwerner and her legal team would file $40 million in the lawsuit against Newport News school officials. The suit accused the school board and former administrators of gross negligence, claiming they ignored multiple warnings the day of the shooting. The lawsuit also notes the student who'd shot Zwerner had a history of random violence. And
See, I think that's so bothersome. He was 6 years old. How how is it okay that we have a 6-year-old with random violence? I'm sorry, I just can't. I'm having trouble getting past this.
the legal fallout only continued. On April 10th of 2023, a grand jury indicted the shooter's mother, Deja Taylor, on state charges of felony child neglect and reckless firearm storage.
Who, in case if anybody missed anything from earlier, we have learned that Miss Deja was released earlier this month. So she's out. It's all good. She did her time for her child doing this. What happened to the kid? There was no charges filed against the child.
Prosecutors also requested a special grand jury to investigate school security issues. Taylor turned herself in on April 13th, and by June 5th, she faced federal charges for relying on a firearm purchase form regarding marijuana use, pleading guilty to those federal charges on June 12th and state charges on August 15th. Fast forward then to the next year. On March 11th of 2024, former Rich Neck assistant principal Ebony Parker was charged with 8 counts of child neglect. A special grand jury report revealed allegations claiming Parker ignored multiple warnings that the child had a gun on the day of the shooting and shut herself in the office after the gunfire started. Now, each count against Parker represents one of the 8 bullets found inside the handgun.
So the 8 counts, again, are for the 8 bullets left inside the weapon. And just so y'all are also aware, no, the child referred to in the court documents as JT was not criminally charged. The decision not to prosecute the 6-year-old was based on both his age and his specific circumstances. Lack of legal capacity, because under the Virginia law, a child as young as 6 is legally considered incapable of forming the required criminal intent to be charged with a crime. With his mental health assessment, the Newport News prosecutors publicly stated they would not seek criminal charges against the boy, citing that he suffers from extreme emotional issues.
And most recently, in November of 2025, a jury awarded the former Newport News teacher, Abigail Zwerner, $10 million in her civil lawsuit. No. The civil trial centered on former assistant principal Ebony Parker, with Zwerner's attorneys arguing she showed total indifference to multiple warnings about a firearm. Defense attorneys countered that Parker exercised reasonable judgment. The jury ultimately sided with Zwerner. Newport News Public Schools rolled out major safety and upgrades following the January 6th shooting at Rich Neck Elementary. Those procedures the division rolled out and mandated then clear backpacks for all students from preschool through 12th grade, banning solid colored bags. The school system also installed 30.
So now we have clear bags, and that's going to fix the problem, right? Clear bags is going to fix the problem because you can't hide anything in a clear bag. You can't wrap anything in that jacket you're going to shove in that clear bag. Clear bags fix everything, right? Right.
Weapon detection systems across high schools and middle schools. And on top of that, high schools in Newport News got new high-volume metal detection systems with walkthrough.
Oh, okay, well, that's good. I mean, we have that in the Fort Bend County and HISD schools. So sometimes it seems a little too late, right?
Through scanners designed to screen large groups. Which brings us to the start of the criminal trial for former Rich Neck assistant principal Ebony Parker, which starts tomorrow. It was originally set for November 17th of 2025, but was continued to this month. The case is on the docket from May 18th through 21st, but proceedings could go even longer if needed. Court is expected to run daily from 9 a.m. to 5 p.m. And again, Parker faces 8 counts of felony child neglect. And as
60-year-olds, please take over. Hell no, absolutely not. We've been working since we were 8. We've had paper routes at sunrise, mowing lawns at noon, bagging groceries by night. No, we don't want to take over. We want to sit down. For the first time in our lives, some of our kids are moving out. You understand what that means? That means for the first time in over 30 years, we might only be responsible for ourselves. And frankly, we don't even want to be responsible for that. We've been in.
We have to close with a good one, guys. Keep that energy.
Crisis mode since Reagan was on TV and the microwave was considered advanced technology. We raised ourselves, then our siblings, then our kids. Some of us are even taking care of our parents. Then we raised the morale of every job where management said, hey, we're a family here, and then cut our damn benefits. And now you want us to run the world? Hell no. We are in our minimal maintenance, maximum sarcasm era. We don't want power. We want peace. We want to drink our coffee while it's hot. We want knees that don't sound like microwave popcorn. We want to not.
And we can thank Cindy for this. I'm going to drop the link in the chat. Yes. And every time I stand up, it's, hold on, let me get my knees popped before I can start my walk.
Be the emergency contact. We are not interested in leadership. We are interested in lower back support. You don't want us in charge anyways. You know what our strategy would be? Fix it. If you don't fix it, duct tape it. If you can't duct tape it, hit it with a stick. If that don't work, get a bigger stick and maybe a hammer. We are the generation that survived hose water, secondhand smoke, and emotional neglect. You think we're going to host town halls at night about feelings? No, we're tired, we're seasoned, we're sarcastic, and we're finally gloriously approaching the phase of our lives where the only person we're legally obligated to manage is ourselves. You want us to take over? We did for 30 years. Now it's your turn. We'll be over here stretching, hydrating, and minding our own damn business.
All right, guys. It's been fun. It's been fun. So we know what we're getting into tomorrow. I appreciate you all for hanging out with us, with me, with Hector, with, my little bit of house drama. Before we leave, always.
You is smart. You is kind. You is important.
All right. So with that, we know what we're looking at getting into tomorrow. I will plan on starting my stream at 4:30, considering we don't lose a wallet or anything crazy in between now and then. So I will look forward to seeing everybody. Yes, I'm going to try to do 4:30 Central. Y'all know I don't know time zones, but I'm going to try and do 4:30 Central because, Hector leaves at 3:34. So that'll give me enough time to get mom situated and get my big butt over here in this chair. We will zoom through the breaks. We will get that opening statements and see where we get tomorrow. So until then, I appreciate you all being here and thank you for spending your evening with me. So peace, rubber out. Y'all have a great rest of your